Wait, please, your lordship. Lordship, I beg to mention item number 4, lordship. In this matter, we have to file our affidavit in reply, lordship. The lordship may kindly grant 6 weeks time.
Counsel for the appellant is granted 4 weeks time to file affidavit in reply. List after 4 weeks.
Obliged.
Lordship, I beg to mention item number 12, Lordship. The
Yes,
consent of the other side. I kindly adjourn for a week, Lordship.
you have not circulated any adjournment slip, sir. You did not circulate any adjournment slip.
Lordship, we could not file yesterday, Lordship.
What is the matter about?
Matter is for Lordship. The appellant is a bank manager. Like appellant was a bank manager. Against
Disciplinary matter,
Lordship.
DP. Counsel for the appellant place for time. The other side has no objection. List after 4 weeks.
Highly Lordship.
May I please, your lordship? My lord, I beg to mention item number 13 of today's list, my lord, 1-3. My lord, due to some personal difficulty, my senior is not ready with the matter today, my lord. Well, may it be listed after 2 weeks.
Learn question. On counsel for the appellant place for time. List up, the other side has no objection. List up for 4 weeks.
Obliged.
May I please, your lordship? My lord, I beg to mention item number 25, my lord.
Hmm.
My lord, my senior, Mr. Bicidas, is not station, my lord.
Who
Mr. Bicidas,
is not here?
no, my lord, he's Kolkata.
It is stated that arguing senior counsel Mr. Das is not available today and the request is made to adjourn the matter. List after 4 weeks.
My lord, I beg to mention item number 10. Kindly adjournment may be given for 4 weeks, my lord.
Why?
As my senior is, as another matter has been fixed and he is not ready for this matter, my lord.
An adjournment slip has been circulated on behalf of the appellant. The other side has no objection. List after 4 weeks.
Must oblige.
May I please, your lordship?
Mm.
Lordship, I beg to mention item number 14, lordship. My senior counsel is out of.
4-0.
Huh?
4-0.
1-4, lordship.
1-4.
Yes, lordship. My senior counsel is out of
These
state.
are all admission matters. You have not circulated a slip. It's really unfortunate. Counsel for the appellant has made a prayer for adjournment. The other side has no objection. List after 6 weeks.
May I please, your lordship? I beg to mention item number 21 and 22, my lord. Both are, my lord, amalgamated matter, my lord. We have a joint prayer, my lord. Kindly pass over the matter for today and take up on 10th of August, my lord. The engaged counsel are from Kolkata, my lord, in both cases, my lord. Can be disposed of on the next date, my lord.
Why not today?
My lord, the last occasion, my lord, they have appeared on 3rd of May, my lord, it was listed, my lord, but this honorable bench was not available, my lord. They are not aware about this date. Today,
A
the case
request
is
is
fixed, my lord.
made to adjourn the matter and list it on 10th August as the arguing counsel comes from another place. List on 10th August as prayed.
Deeply obliged, my lord. May I please, your lordship? Lordship, I'm praying for listing of a matter, lordship, it pertains to transfer, your lordship. May I pray for tomorrow, your lordship? There's some urgency, lordship, because I am hanging, your
It's
lordship.
a writ appeal.
It's a writ appeal, lordship.
When was the order passed by single bench?
Lordship, it's on 11th of July, lordship.
So,
Lordship, actually the matter pertains to Arunachal, lordship, and we have sought permission to file it here, your lordship.
listed tomorrow. Permission granted.
Much obliged, lordship.
My lord, with the consent of the other side, I beg to mention item 13 of the part 2 list, my lord. Mr. M.K. Chaudhary, my lord, the learned senior counsel is out of town for this week, my lord. May I
It
please this matter
stated
with
that
part 2, item 13, my lord.
arguing senior counsel Mr. M.K. Chaudhary is not available today. A request is made to adjourn the matter. List after 4 weeks. The other side has no objection. List after 4 weeks.
I beg to mention item number 26 of today's daily list, my lord. In this case, senior counsel Kamal Agarwal, he is not well, my lord. So, with the consent of the other side, my lord,
It is stated that arguing senior counsel, Mr. K. Agarwal, representing the respondent number 4, is not well. A request is made to adjourn the matter on his behalf, list after 3 weeks. Apply.
My lord, kindly fix the date, my lord.
We have agreed the date by the 22nd of August, is it?
22nd August, all right.
Obliged, deeply obliged, madam. May I please, Lordship? Lordship, I beg to mention item number 18 of today's list, Lordship.
Should we adjourn the entire list?
Lordship.
Should we adjourn the entire list? What should be done? It's really strange. What do you want?
Lordship, in this case, instruction has been sought from the Union of India, Lordship. I have not received the instruction.
Learned counsel, Mr. Students Associate to Shri R. K. D. Chaudhary, PSJ, plays for further opportunity of 3 weeks to receive instructions, list of 3 weeks.
May I please, your lordship? I beg to mention item number 29, your lordship. Engaged counsel is out of station, your lordship.
It is stated that engaged counsel, Mr. Gar,
Yes, your lordship.
is not available today. A request is made to adjourn the matter list after 6 weeks.
Obliged.
Daily list for orders, item 1.
Lordship, in this, we served the notice of the stay on 20th of February, Lordship. Lordship, the affidavit was filed, but that was effective. I made inquiry in the registry.
That
So
was?
I may be allowed to file a fresh affidavit.
Hmm.
On 20th of February, we served the notice to the stay.
Doesn't appear so.
Lordship, that affidavit is not tagged with the record. There was some defect in the affidavit. I may be allowed to file a fresh affidavit.
The report says, the report is of 18 July, no affidavit filed.
That affidavit was defective. That was not tagged with the record. Yeah, I'll file a fresh affidavit.
So the notices are fresh, then the date is gone now.
I'll take fresh step.
All right, notice service has not been effected on the sole respondent till date. Mr. Kale to take fresh steps within 3 days. Thereafter, the stay notices be issued. Rule is made returnable in 6 weeks.
Through the stay, Lordship. Through the stay,
The stay.
Lordship.
Item number 2.
Item number 2, as per office note of 15720, record was called from the office of the deputy commissioner of Kimber. It has not been received, my lord. Reminder has also been. received.
Why the deputy commissioner is not forwarding the record? Who is the government counsel? We have
They take it
sent
to the member.
repeated reminders to the DC
This is Lakhimpur.
and government counsel. The DC Lakhimpur has not forwarded the record despite repeated directions. And government counsel, Mr. So-and-so, shall ensure that the record is forwarded to this court forthwith. If the record is not received by the next date of listing, we shall be compelled to require personal presence of the DC concerned in this court. List on 30th August.
Item number 3.
May I please?
Hmm.
Lordship, they have denied, respondent number 10 and 11 denied to receive the dusty service, Lordship. The affidavit has been filed. In this
Yes.
case, Lordship.
You are not a party in the writ proceedings.
Yes, Lordship.
You are a party.
No,
Then where is your application for leave to file appeal? Whether you can maintain the appeal without that.
no, the petition was filed.
Hmm?
The petition was not filed, Lordship. Well,
Then
it's-
what is the use of this application? There is no prayer seeking leave to file an appeal. How will you maintain the appeal now? Then. अच्छा अभी तो register नहीं हुआ ना?
Lordship, initially, I have a repetition, Lordship, before.
Gentlemen, in the writ petition, the order of which you challenged here, you are not a party. That's for sure.
Yes,
You have not moved any application for grant of leave to file an appeal. You can't, you not being a party, can't file the appeal directly. So we'll dismiss your appeal on this very ground.
Still. I'd like to withdraw. Lordship.
Withdraw.
Yes, with liberty to file a.
Then counsel for the matter comes up for orders on the interlocutory application number so and so. Seeking condonation of delay in filing the connected date appeal. However, we find that the applicant was not party in the current proceedings, and thus, it is necessary before entertaining the appeal that the applicant should seek leave to file an appeal. Counsel for the appellant prays for and is granted 3 weeks time to file the requisite application.
Highly honored.
Item number 5.
May I please, your lordship? Lordship, services awaited upon response number 4 and 5, your lordship.
Service has been effected.
Awaited, your lordship.
Await return of notices issued to the response numbers 4 and 5 for 2 weeks.
Item number 6.
Does anyone appear for the respondent number 3?
The respondent number 3 service, the office note indicates that service has been completed.
It doesn't. No,
Huh?
no. There's no such report.
Service completed, na Prapti?
Hmm.
You said?
In any case, my lord, R3 is the consultant of the NRL.
So you take instructions, Mr. Chaudhary. Take instructions to appear.
Okay.
Hmm?
Lord,
You went to the Supreme Court. The Honorable Supreme Court did not interfere but directed that the appeal should be heard.
yes.
We are prepared, but the matter is pending for service.
I mean,
As a matter of fact, we don't find even
I think,
steps.
I think my learned friend can appear for respondent number 3, my lord.
That's, you make a statement, then we'll record that.
He'll appear, my lord.
Land Counsel, Mr. So your good name, please. M. Deka puts in appearance on behalf of the respondent number 3. The service is complete. All right. We can proceed right now.
Yes.
All right.
May it pleases your lordship.
Hmm.
But this is otherwise, we are against the judgment of the learned single judge by which the rejection of my bid was upheld, my lord, and in fact, that rejection was on a very imaginary ground, my lord, which I will
That
show
your price bid could not be opened without the password.
My lord, may I correct that, my lord? As per the record, your lordship will find on the scheduled date, the price bid was opened.
Hmm.
What was not being able to do is they could not view the content. But that viewing was not done on 26th, it was done on the next date, and therefore they have started they had asked for the login credential, which we ultimately gave, and they have viewed it on 27th. But my lord, let me clarify the whole issue first, my lord.
Hmm.
Your lordship will kindly see, my lord, that if I just take your lordships to the facts first and then the relevant clauses, my lord, that way the entire picture will get clear, my lord, since your lordship is hearing the matter today. Your lordship may kindly come to page 181 first, my lord.
Hmm.
This is a 2-bit system, my lord, and has your lordship come to page 181?
Yes.
Your lordship will find this is the bid acknowledgement. This is in the government e-procurement system.
Hmm.
The date your lordship will find is 7 December 22. That was the last date for submission of the techno as well as the price bid, my lord. So on the last day, on the stipulated date, we had submitted our price bid and techno bid. Now your lordship will find the bidder's name. That is Technip so and so. This is the petitioner before your lordship. Now, your lordship may kindly turn the page and come to page 182. Subsequently, they had evaluated my technical bid, my lord, and they have found me technically qualified and responsive. Your lordship will kindly see page 182, the summary sheet. Your lordship will find both petitioner, serial number 1, your lordship will see is the respondent number 4.
Yes.
Serial number 1 is respondent number 4.
Mm.
Serial number 2 is the petitioner before your lordship. Your lordship will see the bid acceptability status. It is mentioned as techno commercially accepted for quoted tag. That is, now they are accepted for opening of price bid, both bidders. Remark your lordship will find is nil. Now, page 183, if your lordship may kindly come to. This is the tender summary report of now what has happened on 26th. Your lordship will kindly see first. The serial number 1 is respondent number 4, status. Your lordship will find admitted finance. Remarks nil. Then serial number 2 is the petitioner. Your lordship will find we have submitted 7 December. Status, your lordship will, this is very important. Your lordship will find status is admitted finance. Now, what that means is that on 26th, they could open the price bid. They have downloaded the price bid and unlocked it also. And therefore, they opened it and downloaded it. But this was done at 3:49 p.m. Your lordship will find the time. Has your lordship got that? At the side, your lordship sees 26 December, 3:49 p.m. This time is important because the scheduled time was 3 o'clock. They deviated from the scheduled time and opened at 3:49. Be that as it may. Now, your lordship, if kindly come down, your lordship will find the heading technical evaluation summary details, where your lordship will get finance bid opening date 26 December 3 p.m. That was the time. Then your lordship will find finance bid opening summary. Now, this is very important, my lord, because here your lordship will find summary. This is the summary. Price bids are opened. So price bids have been opened on 26th. Now, thereafter, what happens, my lord, I will show from the relevant clause, that is F1 triple T, my lord, that once the price bids are opened, there is an auto-generated process. The system automatically generates the prices of the bidders and put it in a QR comparative chart. And this whole process is automatic. Therefore, this process is provisional. The bid document itself declares so. Now, while doing this, the system could not view my bid. Therefore, the system took only the respondent number 4's bid and declared them as L1. But this declaration, with utmost respect, is only provisional. I will show it to your lordship, my lord. Now, if your lordship kindly see next page, that is the QR comparative chart, my lord. This is that automatic chart. Now here, this is, I'm sorry, this chart is a little legible, so I have better copies for your lordship.
Yes.
Now here, your lordship will find at the top most, your lordship will find L1 amount, L1 vendor. Then in the next page, towards the bottom, your lordship will find lowest amount quoted by R4. Has your lordship got that?
Mm.
So since they have only taken the bid, the prices of R4, it says R4 lowest. Now, with utmost respect, my lord, the learned single judge deemed this to be the final assessment and said that our fates have been sealed on 26. Therefore, thereafter, there is no question of, even if they have asked for clarification subsequently, even if they have viewed or opened, it will have no consequence because on 26, my fate has been sealed. But with utmost respect, my lord, I'll show it from the bid document now, my lord, that on this is purely provisional. After this, what is happening, how the bid document contemplates the evaluation list, first, this auto-generated thing will be done. Thereafter, manually, they will have to download it in their system. They have to evaluate the price bids as per the methodology, which is given at page 164, and the loading parameters. The evaluation and the loading parameters are given out at page 164. So this has to be done. Once this is done, Then the tabulations will be prepared, and these tabulations will be prepared in a PDF format. And finally, this has to be uploaded. And only after that it becomes final. Now, it so happens that many a time, the bidder who first initially emerges as L1 during the auto-generated process, after the evaluation and loading methodologies are applied, then subsequently that position changes. This happens every time, even in this bid also, it will happen so. I will show that also. But if I may just proceed and finish the facts, my lord. Now, if your lordship kindly come to page 186.
Yes.
That was on, your lordship find at 3:49, that process happened. 5 o'clock, the NRL offices closes, I'm told. Now at page 187, towards the bottom, this is the first mail that we received from them on 27/12/22 at about 12:18 p.m. Has your lordship got that? That is at the bottom at page 187. May I read it, my lord?
Yes.
While opening your price bid, BOQ Excel file for tender reference number so-and-so for the supply of so-and-so, it was found that the Excel file is not opening. You are requested to analyze and revert on how the price BOQ file can be opened to view the contents. During our attempt to open the file, it is found to be seeking login credentials. Your lordship will see the file. However, please note that the above request to enable opening of the price BOQ file must not be construed in any way to mean that the prices and or your offer will be used for further bid evaluation. Further bid evaluation, if any, shall be subject to the terms and conditions of the tender and applicable law. NRL reserves the right to reject your offer in accordance with tender provision and applicable law.
Yes.
Then, my lord, we write to them immediately. That is on top, your lordship will find. We were shocked when we got this letter, my lord. And we say, this is at 14/20, same date. It is surprising to note that the Excel file is not opening. We are able to open the same in our system without any issue or prompt. In case it is asking for the login credential for opening in your system, you may please use email ID so-and-so as the login name. Password for the email is so-and-so. Then, my lord, again, they write to us on at about 4:46 p.m., same date. We are still unable to open the file even now. Sharing below screenshot for your information. This screenshot, your lordship will find at page 189. This has some relevance, my lord, at page 189. Your lordship will see it says, you do not have permission to open this workbook. Now, why I said that it has some relevance, because one of the ground for rejection is that it is rejected as per a clause F1BBB. But that clause is relating that in case suppose the price bid is corrupt, if the format is corrupt, or in that case there is a rejection. Now, if suppose my bid was corrupt, then your lordship will kindly see page 190. This would have been how the screenshot, how it would have shown in the computer.
Okay.
The file is corrupt and cannot be opened. So our bid is not corrupt. It is only they could not view it because it sought for the login credentials. That is what I'm trying to impress upon your lordship. Now, thereafter, again, we had, if your lordship kindly comes, I'm sorry, I'm making your lordship come back to page 186 again, my lord. The last email. Now, once they have sent that mail, we replied to them again at 5:43 p.m. We checked again with our IT team who have confirmed that with the login credentials given to you, the document should open in your system as well. You may like to check with your IT team if there is some issue to be resolved in your system, which is preventing the file to open. Alternately, you may also check the status of document opening the NRL. If they are able to open the documents in their system and share the same with you. Now, my lord, if I may just pause here for a moment. On 27/12/22, ultimately NRL opened it. I'm sorry, NRL could view it. And this is at page 208, your lordship will find. They have admitted in their affidavit, and also at page 191, when this was challenged, first time before the learned single judge, at page 191 is the order where there is a submission by the lawyer for the NRL. Your lordship will find that at page 193. Paragraph 3, it would suffice to record herein that on appointed query of the court, upon instruction, the learned counsel for R2 has submitted that he has received instruction to the effect that the price bid of the petitioner could be opened after receipt of the password from the petitioner. Accordingly, it appears that it is not in dispute that before the rejection of the price bid of the petitioner by impugned order, that is 2/123, the respondent authorities had been able to open the price bid submitted by the petitioner. And at page 208, the date is given. 208 is the affidavit filed by the R2. At paragraph 7, they have clearly said that the respondent number 2 states that being able to view the price bid, your lordship will see view the price bid of the petitioner on 27/12/22. So it is an admitted fact that on 27/12/22, they could view the price bid. Anything else with the facts? I'll go to the no? Clauses. No, where's my document? Give it. Should I first do that NIC thing? That is 208. You indicate when. Now which clause should I start?
It's fine. All right. Yes.
Now, if I may just take, well, the impugned rejection that your lordship will find at 71, page 71.
Yes.
This is dated 2/123. Your lordship will kindly see, we regret to inform you that your price bid cannot be considered for further evaluation as the contents of the price bid are not viewable without login credentials. I have already shown your lordship from their own affidavit that on 27, they have viewed it.
With the login credentials,
Yes,
but without
yes,
that.
yes, yes. Then your lordship will find as such your offer stands rejected in accordance with F1H, read with clause F1BBB of the notice inviting tender of the bidding documents for reactor and regenerator package and applicable law so and so. Now, if I may just take your lordship straight to the NIT, my lord. The NIT starts at page 83. Your lordship will kindly have page 111. This is page 110, the clause starts. This is bidding document. Your lordship will find F1. Bidding document and F1H that your lordship will find at 111. Has your lordship got it? This is one of the clause relying on which they have rejected my bid. Now, what does this, your lordship will kindly see what it says. In order to maintain confidentiality of all documents and drawings submitted by bidder in response to its unpriced bids only, shall upload password protected PDF files only in the portable. For ease, same password shall be used for all the uploaded PDF documents, which will be subsequently shared by email to the officers of so and so. Now, clause F1H stipulates that in case of techno-commercial bid, that is unpriced bid, all the documents and drawings which will be shared, this has to be shared through a protected file, password protected file. But nowhere in clause H says that in case your price that you should not protect your price bid. This is not mentioned. This is something that they are imagining because it only talks about unpriced bids and nothing about price bid. Am I clear, my lord? Now, if your lordship kindly come to the next page. This clause X, I may just show your lordship on the next page, which says during the tendering stage, all communication will be made through e-procurement portal. However, post submission of bids, all communication clarification shall be sought outside the e-procurement portal. So the scope of clarification comes from here, and there's another clause which I'll show your lordship, which is at page 114. Now at page 114 is the F1TT. This is a very important clause which we are. What? I'm told that your lordship's copy may not be very clear, so we are handing over a clear copy of
It's quite clear.
F1TT.
It's quite clear. Carry on.
Clear, my lord?
Up. It's okay.
My lord.
Carry on, carry on.
F1TT, my lord. Your lordship will see bidders to note that the comparative system BOQ comparative chart generated after opening of the price bids is system generated and may not take into consideration of various loading and evaluation criteria as defined in the bid document. Initially I was submitting before your lordship that BOQ comparative chart, which I have already shown your lordship, is only system generated, and therefore it is provisional because it may not take into account the evaluation and loading criteria. This is very clear from the first TT clause, my lord. Now the next paragraph is, and my lord, the first part is relating to the auto-generated. Now your lordship might see the second part. The actual comparative tabulation in PDF format, considering all loading and evaluation parameters of the tender for techno-commercially acceptable offers will be uploaded on CPP portal by the tender inviting authority after opening of price bids, and the same shall be considered as final. So therefore, there are two stages, in my perception, my lord, is stipulated under the bid document. One, which is the auto-generated. After that, there is a manual intervention required, where they will have to, after the download, they will have to open it, see it for themselves, compare the price bids, apply the formula that is given at page 164, work and prepare that tabulation chart. Once that is done, then they will upload that in the PDF format and put it in the CPP court portal, whereby they will declare what is the final result, my lord. Now, with utmost respect, my lord, in this tender, admittedly on that day, my lord, as said by the learned counsel for respondent, they have not done this part. The reason being that since there is only one bid which has been accepted in the auto-generated and they have rejected the second bidder, therefore the evaluation was not done. I will come back to that because that cannot be. That means this is incomplete. The evaluation has to be done. I will show that, my lord. In fact, we have visited the CPP portal and this was done when? Yesterday, my lord. Your lordship will find in process 2, financial evaluation, there is no tick mark. Your lordship will kindly see the status. Financial evaluation, there is no tick mark. Admittedly, this evaluation is not done. This was in fact also my learned friend had fairly considered to that also. Now, next part your lordship will kindly see.
Yes.
Bidders note that no contractual obligation or complaints whatsoever shall be entertained against the system generated BOQ comparative chart. Now, to my understanding, my lord, why this is given, that there will be no contractual obligation, because on the first day in the auto-generated method, if one particular bidder emerges as L1, he shall not have any contractual obligations. He cannot later on come and say, no, I had emerged as L1, therefore I am the L1. Because after the evaluation criteria and methodology is applied, that position may change. Subsequently, another bidder might become L1 and that would be the final. So at that stage, he cannot come and have a complaint, at that auto-generated BOQ chart, I was L1. So therefore, there is no contractual obligation. That is purely a provisional thing, an auto-generated, system-generated. Subsequently, manually, an evaluation has to be done. With utmost respect, this has not been done. Then my lord, the next clause, post evaluation of the bids, the letter of acceptance will be issued to the successful bidder. So it says post evaluation of the bids. Here, the LOA was issued on 8/6/23 without evaluation. Till date, admittedly, no evaluation done. Then 115, if your lordship kindly come, this is clause AAA. Here it says the bidder shall adhere to the following provision of the bidding documents without taking any deviation, failing which the bid shall be considered to be non-responsive and are liable to be rejected. Clause D is important to us. It says price BOQ format. Now, if I may just pause here for a moment, my lord. BOQ format is already provided. I will show from another clause, my lord. It is already provided when we download all documents. We download this BOQ format. In that BOQ format, subsequently, we will fill up the prices wherever the blank places are there. And thereafter, we upload this BOQ format. Suppose for some reason we modify the format or we change the format, then that system will not even accept it. The system will reject it because this is the mandatory BOQ format which has been prepared and given to us. We cannot modify it. We cannot change it. It is a fixed format. Now, if suppose we do that, then I will be facing a rejection. Am I clear, my lord?
Yes.
Next, BBB. If your lordship kindly see BBB. This is another clause which they had referred to in the rejection order. Bidders to ensure submission of correct file format in the portal. In case cannot open the bids due to corrupt bid files formats, the offer shall be rejected. So when the price bid will be rejected is given here. That is, if suppose my file is corrupt, for some reason it is corrupt, the file became corrupted because of virus or anything else, then I will face a rejection. But this is not the case. I have already demonstrated before your lordship through those two snapshots, my lord, which indicates in case it is a corrupt file, what will happen. And in fact, they have already admitted that they have viewed it. So if obviously it is not a corrupt file, because if the file was corrupt, they could not have viewed it.
Yes.
Now your lordship may kindly come to page 116. This is a clause whereby the respondent authorities can sought for clarification. EEE, the owner in its sole discretion and without incurring any obligation or liability reserves the right at any time. C, your lordship will see, consult with any bidder in order to receive clarification or further information. So this clause is there. And according to this clause only on 27, they sought for the login credentials, which we provided. And after we provided it, they had viewed it on 27 itself.
Yes.
Now your lordship may come to page 118. Page 118 is the instructions to bidders. Here at page 122, your lordship will find who is an L1 bidder. The definition. L1 bidder shall have the meaning as set out in clause 43. Now that your lordship will find at page 123. No, 43 is at, we'll straight go there. 153. I'm sorry, 153. Now, before taking your lordship to 43, 39 for a moment, if your lordship kindly see. 39 is evaluation of techno-commercial bids. Has your lordship got at page 151? Why I'm showing this? Because under this, there is a rejection criteria, which they are now trying to apply. But with utmost respect, this is only in respect of a techno-commercial bid. Because your lordship will kindly see clause 39, evaluation of techno-commercial bids. Then 39.3, bids rejection criteria. Here, if your lordship turn the page, second bullet point, if your lordship kindly see, does not submit bid in prescribed format, making it impossible to evaluate the bid, indulgence in tempering of tender documents. So this is only in respect of techno-commercial bids, because this is part of 39. Then 41 is opening of price bid.
Yes.
Open this. Opening of price bid, 41. Price bid of only those bidders whose techno-commercial bids are determined to be technically and commercially acceptable by NRL shall be opened. Bidders selected for opening of their prize bid shall be informed about the date, time, and place of prize bid opening. So there is no dispute here that I'm commercially qualified, and therefore it was open. In fact, my prize bid was open, but it could not be viewed on that scheduled date, not time. Then your lordship will kindly see page 153. Now this is of some relevance, because it may so happen that sometime after the prize bid is open, there could be some arithmetical errors. Now there is a provision which says you can correct. Kindly see, my lord, correction of arithmetical errors. The consultant shall correct arithmetical errors on the following basis. Now this the consultant can only do subsequently. That is at the subsequent opening stage, not at the auto-generated stage. Where bidders have been asked to quote unit rates based on SP forms, the prices quoted by the bidders shall be checked for arithmetic correction, if any, based on rate and amount filled by the bidder in the so-and-so form formats. In the event of any discrepancy between the rate amount provided by the bidder in figures and words, the rate amount provided in words shall prevail. Also, in case of difference in lump sum prices versus its breakup provisions defined in the schedule of rates, preamble to schedule of rates shall prevail. Bidders shall be requested to accept correction of arithmetical errors in the price bid. Failure to accept the correction in accordance with clause 34.1 of ITB shall result in rejection of the e-bid, and bid security shall be forfeited. So this is relating to correction of arithmetical errors. Now 43, which is important, which is evaluation and comparison of price bid. Clause 43 at page 153. The consultant shall compare the price bids based on the evaluation methodology and loading criteria, if any, provided in BDS to determine the bidder with the lowest evaluated price bid. Now this your lordship will find at 164. Your lordship will kindly have page 164. The evaluation and comparison of bids. Has your lordship got it?
Yes, yes.
The evaluation and comparison of bids shall be carried out as per following. The total amount quoted shall be calculated, established based on price quoted in the schedule of rate forms, SP forms, after arithmetic check in line with clause 42 and 43 of ITB. Number two, to arrive at the evaluated price, aggregate of the following shall be considered. A, total lump sum price quoted by bidder in so-and-so form, taxes and duties as per form so-and-so. C, loading criteria as per annexure so-and-so to special conditions of contract, considering the guaranteed utilities consumption figures quoted in form so-and-so and so-and-so. That means they have to check the value, whether it's feasible or not. Then D, IGST, GST, so-and-so. Then 3 is that is not applicable. 4 is price preference as per the PPLC policy as per so-and-so, which is given at page 162. Then 5 and 6 are not applicable to this tender. So when a detailed methodology is given, it doesn't mean that once that auto-generator declares something, that is fine, that becomes final. Even in a situation where it is only one bidder, this evaluation has to ultimately be completed. You cannot left it incomplete, because once you do this methodology, you apply these formulas, it may so happen that there may be some lacking. This is not done with utmost respect, my lord. Now 154 is the award. That at page 154, the award criteria. Clause 45. Subject to clause 46.1 of ITB, NRL shall award the contract to the L1 bidder who has been determined to be the lowest evaluated price bid in line with ITB clause 43 above. 43 I have already given to your lordship, successful bidder. This has, with utmost respect, I have shown your lordship from their even yesterday's format, it indicates the financial evaluation has not been done. Yet they have issued the LOA. But the arbitrariness makes loud from the on the face of the record, my lord. Now, if your lordship, my lord, take up the page, where is the system generator?
System generated is 185 page.
Lord, page 164 once, my lord. 166. This
Yes.
is the submission of bids, my lord, what I was referring initially. One sixty-six.
No, the-
166.
Yes.
My lord, your lordship, these are the instructions for online bids, my lord. Now, your lordship, the third last paragraph, if I may trouble your lordship with. Bidders are requested to note that they should necessarily submit their financial bids in the format provided and no other format is acceptable. My lord, I was saying, my lord, that BOQ format, the bid has to be given in the BOQ format. Now, if I change that format, the system will not accept it. And later on also, my lord, they cannot even view it. Therefore, that contention of there that I have modified is with utmost respect not correct, my lord. I have not done any modification. Then your lordship will kindly see if the price bids have been given as a standard BOQ format with the tender document, then the same is to be downloaded and to be filled by all the bidders. Bidders are required to download the BOQ file, open it and complete the white colored unprotected cells with their respective financial codes and other details such as so and so. No other cells should be changed. Once the details have been completed, the bidder should save it and submit it online without changing the file name. If the BOQ file is found to be modified by the bidder, the bid will be rejected. The server time will be considered as the standard time for referencing the deadlines for submission of the bids by the bidders, opening of bids, etc. The bidders should follow this time during bid submission. All the documents being submitted by the bidders would be encrypted using PKI encryption techniques to ensure the secrecy of the data. The data entered cannot be viewed by unauthorized persons until the time of bid opening. The confidentiality of the bids is maintained using the secured socket layer so-and-so encryption technology. Data storage encryption of sensitive fields is done. The uploaded tender documents become readable only after tender opening by authorized bids opener. So, my lord, it is very clear that one can only open this after submitting, only after the authorities opens it, not before that. So no one can temper it. No one can do anything, my lord. Now, this becomes more clear through a query that they had sought, which your lordship will get a 212. This is the question or the answer? At 212, NRL sought for a clarification. This is on 18/1/23. Very relevant, my lord. That's why I'm referring to it at 212. This is from the Senior Director IT National Informatics Center, addressed to them. Subject request for clarification regarding price bid. Now, your lordship will kindly see the query. Once the price bids have been uploaded on the CPP portal, whether anyone, including the bidder, can make changes to the uploaded BOQ Excel file after the bid due date has expired. Now, your lordship kindly see the answer, which is as page 213. This is the answer given by the senior most from the National Informatics Center. They are the creator, my lord. System's BOQ template is uploaded only after password protected by the department. So the bidders cannot modify the BOQ, and system only accepts the same BOQ in the bid submission, which was uploaded by the TIA during creation of tender. Next, after bid submission, due date and time, bidder cannot modify BOQ, and even she cannot modify the bids also. So this makes it abundantly clear, my lord, that first, if I modify the format, it will not be accepted. That is not the case here. Secondly, my lord, for some reason, on 26th, even if they could not view the contents, I cannot change the contents of my bid.
Yes.
Once it is submitted, it is sealed. And we have submitted during within the stipulated time. Now, one more document, my lord, this is relating to a FAQ, answer to a question, which is at page 331. This we have asked. No? We have filed this in our rejoinder, and this is at page 330. Now, if your lordship kindly see the last question at 331, question number 9, second last question, I correct myself. I generated the BOQ comparative chart. I found that one of the bidders' data is not getting reflected in the comparative chart. How to handle it? This was the question, my lord. The system generates the comparative chart from the BOQ uploaded by the bidders. If the bidder makes any mistake in the sheet name or any of the values, then the system will not be able to read the data from the BOQ uploaded and hence may get missed out from the comparative chart. The department user may take a decision to accept or reject that depending on the nature of mistake and regenerated the comparative chart manually and upload this comparative chart along with the financial summary, which can be seen by the general public. So, my lord, on 27, they have seen it. They could have uploaded it, which they did not do. They could have uploaded it in the portal. Public could have seen it, which they did not do. Moreover, my lord, after viewing it, they didn't do the evaluation. They could have done it. Ultimately, it was before them. It is not a case that they could not open. If that was a case, I'm out.
Don't repeat yourself.
I'm sorry, my lord. Then now, in the affidavit that they have filed, their contention is that before they rejected, they had made some discussion. And this was in relation to a query posed by this honorable court. Now that your lordship will find at page 200, where is the affidavit? At page 202, the affidavit starts, paragraph. Or the additional affidavit. I'm sorry, my lord, this has come in the additional affidavit, which is at page 219. Because subsequently, a question was put to them, and then an additional affidavit was filed before this honorable court, 219. They are relying on a discussion which was held between the competent authorities of NRL and the independent external monitors. Now this, and at paragraph 4, which is at page 222, your lordship will find that the IEMs were of the view that the petitioner had made a serious mistake by submitting a password protected file. It was further observed that the tender provision makes it clear that in case of the bid other than the unpriced bid is in different format, that is encrypted or password protected format and cannot be opened, it is liable for rejection. And since the price bid of the petitioner could not be viewed on the date of opening of price bids, their offer cannot be considered for further evaluation and their offer is liable for rejection. It is stated herein that the NRL management has duly taken into consideration the aforesaid observations of IEMs while rejecting the price bid of the petitioner. Now, interestingly, my lord, the minutes are at 224 and at 227, if your lordship kindly see, this was signed on 4 January 23. Kindly see towards the end. The date is given 2023.1.4. That is after issuing the rejection mail. And on affidavit, they say that they have taken note of this discussion, which was not even signed. And here, if I may just indicate from page 227, my lord.
Come to 2 to 4. What is the date mentioned at the top of the?
My lord, that
first
is
meeting?
the date when the meeting was held. That is 29/12. But my point is that this was not signed. This was signed on 4th.
Okay.
My lord, that is the point that I'm trying to draw home, my lord,
Very well.
because it was an unsigned document
Yes.
as far as on 2nd is concerned. And in the body of the email letter, nothing, they don't mention anything about this. This is only later on in the affidavit, they mention that we have taken due consideration.
That's all, Mr. Goswami. I think you have said enough. Thank
Well,
you.
Huh? Minute, wait. I may come back to your lordship after they. It's all right.
Wait with your lordship. My lord, my learned friend has brought the facts for detail, therefore I'll not repeat the same, my lord. If lordships would kindly come to page 226. That's the decision-making process, my lord. Public order publicly made has to be construed in the context in which it is made. Now, it is a fact, my lord, on 29/12/22, the discussion took place and the proceedings were digitally signed only on 4/1/2023. Now, let me read this, my lord. This will give a clear idea as to why we did not accept their price bid. Please come to page 226, last sub-para, my lord, background. GM Project so-and-so gave a brief on the issue being faced against the global open tender for procurement of reactor and regenerator reject package for so-and-so unit. Against this tender, offers were received from 2 agencies which were found techno-commercially acceptable. That is my learned friend's client and my learned friend Dr. Saraf's client. Upon opening of the price bid on 26/12/22, it was found that the Excel cell, that the BOQ Excel file of the Technip submitted on portal failed to open. It was seeking login credentials, including a login email ID and password for viewing. As such, by email dated 27/12/22, so-and-so consultant, so-and-so industrial, so informed Technip on the above request how the file can be opened, while reserving the right to reject their bid in accordance with the tender conditions and applicable laws. Pursuant to the above, Technip has provided the original credentials with which NRL was able to access their price bid. While bidding document provided that the unpriced bid of the bidders may be password protected to maintain confidentiality of the technical offer, there is no express provision in the tender enabling bidder to submit the price bid with password protection. Further, the following provision, that is clause FIBBB of the NIT 6, a rejection of the offer in case NRL, the consultant, is not able to open the same. Bidders to ensure submission of correct file in format in the portal in case NRL so-and-so cannot open the file due to corrupt bad files. My learned friend did not read the next. After this slash, there is a word formats of the at page 111. The offer will be rejected. Points discussed in the meeting. During the discussion, it was felt that Technip had made a serious mistake by submitting a password protected file and thereby subverting the transparency on the tendering process. Moreover, the tender provision is also amply clear that in case the bid is in a different format, that is encrypted or password protected format, and the same cannot be open, is liable to be rejected. So this is the reason, my lord. My lord will kindly come to page 375. Contrary to what is being submitted before lordships today, what was submitted before the learned single judge, my lord? Please come to para 375.
Page.
Page 375.
Yes.
It's internal page 7 of the judgment, line about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Line about 15 from bottom.
Thus, it is contained.
Thus, it is contended that merely because BOQ Excel file containing the price bid of the petitioner was a password protected one, and the e-procurement portal did not read the data and the rates from the said BOQ Excel file uploaded successfully on e-procurement portal by the petitioner, resulting in non-reflection of the data and the rates from the said BOQ Excel file in the system generated BOQ's comparative statement. The tendering authority, considering the alleged mistake, which by no stretch was an intentional one, ought to have regenerated the comparative statement manually and uploaded such a comparative statement along with the financial summary on the pre-procurement portal. Such non-intervention on the part of the tendering authority to regenerate and upload the comparative statement manually on the procurement was clearly an arbitrary and discriminatory. So they admit that it was a mistake, my lord. If it was a mistake, has it not missed the bus, my lord? It was a mistake. So therefore, to my lord, improve upon that argument before lordships by saying that we resorted to arbitrariness in not manually evaluating his financial bill. In my humble submission, my lord, this argument would not lie.
What was the reason of opening it thereafter? Why did you manually open it?
My lord, the idea was to my lord, just to, so that my lord, we also can satisfy ourselves. When it transpired, my lord, lordship will kindly come to 111, page 111 for a moment, which my learned friend has referred. 111, my lord.
Yes.
Page 111, H. In order to maintain confidentiality of all documents and drawings submitted by the bidder, in response to its unpriced bid only, bidder shall upload a password protected PDF file. So in respect of price bid, my lord, there's
There
no
was a supposed
restriction.
password.
It should be protected. Now, lordship
what-
will kindly come to page
Mr.
111.
Chaudhary, Mr. Chaudhary, we are asking, what was the reason to then get the password and open the file?
Yes, that we have explained, my lord, in our affidavit, my lord, at page number 375. One second, my lord. 207, my lord.
Hmm.
Para 5 and 6, my lord. That the respondent number 2 states that since the price bid file uploaded by the petitioner could not be viewed on the date of opening of the price bid upon opening the same on CPP portal, the said file format uploaded by the petitioner shall be deemed to be in a different format or a corrupt file as per clause so and so. For all
Yeah,
intent and
Mr.
purpose.
Chaudhary, you have done it, that's a different thing.
Yeah.
What was the need to do it? What was the
Well,
reason behind
We
this?
felt that, my lord, at least some transparency should be there in the process. It was not necessary. Lordship is absolutely correct, my lord. Like with no manner of doubt. We are not obliged to do that, but we still need it to show, my lord. Just to find out actually what is the reason, what is wrong. No other purpose, my lord. Then at para 6 also we have stated that on 27/12/22, respondent number 3.
This was
And-
probably keeping in view the interest of the legal fraternity.
could be
Give them a handle.
some hope, my lord.
Yes.
Yes.
Okay.
Then, my lord, para 24 of the same affidavit.
Yes. Yes.
Judgment, para 24 of the judgment, my lord.
Judgment.
Yes. I think the learned single judge has summarized the legal position very clearly, my lord. Page 409.
Hmm.
In fact, my lord, this aspect which your lordship is, asking for has also been dealt with. From the text and tenor of the content of the communications exchanged from the end of the respondent number 2
Hmm.
and respondent number 3 during the period from 27/12/22 to 2/1/23, it is discernible that tendering authority wanted to know the exact reason as to why BOQ Excel file containing the price bid of the petitioner did not open at the stage of price
Right.
bid opening.
I-
Clause FX and clause so and so of the NIT bidding document permitted such communication. After being aware about exact reason behind such non-opening of the price bid of the petitioner, which had resulted due to inaccessibility of the data and the rates contained in the password protected BOQ Excel file, barring the system at the e-procurement portal to reflect the same in the automatically generated BOQ comparative statement, the information conveyed by email dated 2/1/23 to the effect that price bid of the petitioner could not be considered for further evaluation due to its non-viewability without login credential was only an affirmation of the fact of rejection of the price bid of the petitioner. At the post-invalidation stage, by email dated 2/1/23, tendering authority had only reiterated the fact of invalidation of the price bid of the petitioner, which had already been invalidated on 26/12/22 after being ascertaining itself fully about the exact reason behind the defective nature of the petitioner.
So this was basically to make doubly sure.
Yes. So in that view of the matter, my lord, and the judicial view, my lord, preponderance of judicial view. Now, my lord, what was said in 1994 in Tata Cellular, my lord, now it has been reaffirmed recently in so many judgments, my lord. Well, it's not a case where they're alleging mala fide.
That's not good.
So, my lord, it's a bona fide exercise of power. Could be a case where there could be a second view possible. And my lord, the NRL being the employer, having, my lord, incorporated the conditions, they are the best judge to give an interpretation of the conditions of the NIT. I think these are all settled position, my lord. But then I just rely on one judgment, my lord.
Sure.
That Silpi. I'll rely on two judgment, my lord. Silpi construction, that is 2020, 16 SCC 489. Para 20. Sorry. 2020, 16 SCC 489.
Yes.
My lord, may kindly come to page 502, placetam A on top. Authority which floats the contract or tender and has authored the tender document is the best judge as to how the documents have to be interpreted. If two interpretations are possible, then the interpretation of the author must be accepted. The court will only interfere to prevent arbitrariness, irrationality, bias, malafide, or perversity. With this approach in mind, we shall deal with the present case. Then, my lord, one old case, what had happened? A person had one of the bidder, my lord, 2011, 5 SCC 103.
Hmm. Yes.
Page 103, my lord. My lord will kindly come to 105, para 8 and 9 for the facts.
Yeah. Yes.
Para 8 and 9. The question for decision in this case is whether, I'm sorry, my lord.
Yes, carry on.
The question for decision in this case is whether, on account of corrigendum whereby provision of section 3 of the tender document and section 7 of the bidder checklist were amended, the appellant was disqualified from consideration in view of the fact that along with the tender document it had filed, through inadvertence or otherwise, a copy of the ISO so-and-so of the previous year instead of the current year, although it did have the same valid ISO certificate at the time of making of the bid. So, my lord, in fact, he was in possession, but inadvertently it was given. So, my lord will kindly come to para 47 at page 113. The submission made on behalf of the appellant proceeds on the basis, para 47 at page 113, my lord.
Yes.
The submission made on behalf of the appellant proceeds on the basis that it was entitled almost as a matter of right not to submit the document required to be submitted along with the bid document on the supposition that if such documents were valid and active, they could be submitted at the time of signing of the memorandum of understanding. The appellant had a valid and active ISO certification, which is not submitted along with the bid document, may be due to inadvertence, but whether such explanation was to be accepted or not lay within the discretionary power of the authority inviting the bids. Decision taken to reject the technical bid cannot be said to be perverse or arbitrary. So therefore, my humble submission is, my lord, it's an open and shut case where they admit before the learned single judge that it was a mistake, but not an intended mistake, unintended mistake. Now, having admitted before the learned single judge, my lord, and having not conformed to the requirements of the NIT, now it is too late in the day, my lord, to come and put forward legal argument, my lord. Moreover, my lord, there is no allegation of malafide in appeal. And finally, my argument is, my lord, writ appeal is an appeal on principle. Merely because another view is possible, my lord, lordships will not accept that. That's my humble submission. And my lord, there is a great urgency in the work. Every day we're losing about 85
That-
crores.
That we cannot.
Tip level.
Yes, no.
Private.
Yes, please.
Well, I will be very short and 3-4 points only. Well, the condition which you also find at page 111 is uses the word only. That the passwords protected should be only in the technical.
One price page.
Now, the use of the word only means that others are excluded and only it is to be done in a particular way. Now, the rejection criteria specifically says that the terms and conditions which are not followed, that the tender will be rejected. My friend was saying that on the day of opening, it was only a provisional, and thereafter the uploading etc. is to be done, and thereby it was not finalized. If the provisional one is not there, then the question of uploading or not uploading does not arise. His bit was not there on that day, so how it bit can be said that it will be uploaded? Only those bits which were there on that, it can be uploaded and loaded. Now, Lordship is aware, why judgment one judgment I may place central call fields. Your Lordship is aware of that. In that case, the bank guarantee was not given a particular format which was prescribed in the bid itself. The issue which was there before court, your Lordship is page paragraph 27.
Yes.
What is extraordinary? Page 631,
Hmm.
para 27.
Yes.
What is extraordinary about this case is that the employer, that is CCL, seeks to adhere to the terms of the NIT and the GTC issued by it. But the submission of JBC is that CCL should actually deviate from the terms of these documents so as to benefit JBC. Indeed, despite all the specific requirement that the bank guarantee should be submitted in a particular format, JBC claims an entitlement to a deviation in this regard on the ground that the prescription format was not a non-essential term of the NIT and GTC. Who is to decide the issue of essentiality? Does CCL, with whom the contract has been entered into by the Custodial, have no say in the matters, because adverting to this, it is necessary to get clarity on some content. Para 28 says, in the present day, in the computation, the person concerned is aware that what are the conditions. Now, thereafter, you see, the apex court, considering the judgment of Najir Ahmed, said that when the particular things is likely to be done in a particular manner, then it has to be done in that manner only. So when the NIT conditions, there it says, in paragraph in paragraph 52,
Hmm.
there is no valid reason, second paragraph, there is no valid reason for give up this steady principle or not to apply to the mutual bid documents. This principle is just to be applied in the contextual disputes, particularly in commercial context, or bidding up to the commercial bids, where there is stiff competition. It must follow from the application principle laid down that the Najir Ahmed, that if the employer prescribes a particular format for bank guarantee to be furnished, then a bidder ought to submit the bank guarantee in that particular format only and not to other format. Now, the apex was also that there's nothing like essential conditions, ancillary conditions. It has to be done in a particular manner only. And the recent 10 million, you also have seen that the apex court not only said that in the tender matters, the disputed, the person who's go to civil, the contempt for damages, even if it has been done there to the extent of arbitrarily also, then also, and the public interest in the stopping the projects, the apex court said that no, we should not interfere. In this case, the learned single judge had dealt with in detail every aspect of the matter. Once the matter has been dealt with in so details, and no such a glaring perversity or something in the wrong in the judgment has been pointed out, then in my humble submission, the appellants have no case to make out to assess the judgment of the learned single judge. And we have also placed after the LO, this was letter is was issued.
LOA has been issued.
Immediately with LOC letter. intent. LOI, rejection. And the LOI, we also place the orders, my lord, for the aviation. Later international.
He discussed that.
28-6 itself.
My lord, immediately on receipt of the letter, we place the orders also, everything. And my lord, after all the projects, my lord, it has been, my lord, the project is now, my lord, pending for a long time, and I will give the letter of intent also, my lord.
Yes,
My lord, letter of acceptance, I will give only one copy, I'm sorry, my lord.
it's okay.
So my submission, my lord, the appeal deserve to be rejected, my lord.
ये दिया
And,
है। आपके पास है LOI दिया था ना ये पास है there. Yes, very well.
I'm obliged to you.
Yes,
So just two documents, my lord, which is one is the CVC guideline, my lord. I just wanted to rely something from that, my lord. Because this is a CVC guideline letter, my lord. Now, why I'm relying this, my lord, your lordship has said that double H clause, my lord. There is no express provision for not giving or giving about the password protected in relation to a price bid. It only says in case of the unpriced bid only, it will be
and
protected.
supposing we hold so and then ask them to blacklist you for the future tenders, then what? For stalling the project for almost 3 months. Your stay was not granted initially.
My lord,
Then
this
after
is-
the judgment was reserved, there was a stay by single bench.
Well,
It's
that
right.
was because, my lord, back then they had issued the.
Yes, so for stalling such a project, despite being non-compliant, why should a cost be imposed on your client? Let us
With
know.
utmost respect, my lord. This is
Yes.
not a case that I'm not technically not qualified, my lord.
Question
That
here
is
is,
not
Mr.
the case, my
Goswami,
lord.
your client is a know-how of how tenders are to be filed.
True, my lord.
The conditions are very clear,
True.
only on price bids, password protected,
True.
nothing else is
My
required. to be
lord,
trusted.
if I may intervene here, my lord, in
Sure.
the case of, my lord, in fact, my lord, this thing had come to me also. Therefore, I had asked from the technical team what actually had happened. Because if they had
Yes.
given, if they had
Yes,
set
it
a
is absolutely
password,
open and shut case, Mr. Goswami.
my lord, with,
And we have our serious reservations now.
my lord,
We are telling you.
but,
So
if I may just
very well.
rely on this CVC one, my lord, if our lordship will kindly see paragraph 2. The commission would reiterate that whatever pre-qualification, evaluation, exclusion criteria which the organization wants to adopt should be made explicit at the time of inviting tenders so that basic
What
concept.
more is required to be explicit? What
But-
more explicit expression you want?
My
It's
lord,
very clear. Unpriced bids, that's all.
but my lord, it doesn't.
And wrong
restrict.
format, rejection.
My lord,
Two
there
things
is
are there.
no clause with utmost respect in the bid document that in case I put a password, then my price bid would be rejected.
All right, thank you. That's all.
All right, my lord. Deeply obliged, my lord.
Dismiss with the cost of 1 lakh rupees.
Deeply obliged, my lord. You want to speak with them more, you can give me more fast.
Yes, next.
Item number 7.
Please, your lordship. Lordship, here the notice has returned unserved and with a written.
Not found available.
Yes, with a note that, yes,
Yes.
that the address is absent always.
Hmm.
That is the note.
So then what to do? To get him served. There is no way out. Let fresh notice be issued to the spot number 1. Dusty service. Dusty service is permitted. Rule is made returnable in 3 weeks.
Obliged.
Item number 8.
Yes, letter of 14.3, your lordship, that's a point that they have to produce. If they say that it is supplied, then it's up to your lordship, that other argued you. Your lordship will see the records.
Yes, Mr. Chaudhary.
That's not my domain, it's my.
Obviously.
Yes, he has to.
And this supply ultimately could not have been given to anybody because under the scheme of the government of India,
See,
money,
there is
What?
one letter of.
money for the uniform is to be transferred directly to the account of the students. So ultimately, they might have gone to the students, not to any contract.
I'm sorry to say, why my learned friend argued on that day? I knew, my lord, honestly, I knew it, I didn't say before the court.
Hmm.
I was present, that was the counsel of the government appeared before the court said it will go directly. I didn't say, my lord, because that's the only case where my learned friend projected. That if this is there, I have no other case. I
There are-
remember frankly.
There are two more. I'm just-
There can be any other argument.
I'm
I'm
pla-
sorry to say.
I'm placing, man. I'm
It's up
placing.
to him.
There is one of the points. From the list of dates I have given.
What's your oral stand on that?
Yes, ma'am.
Mr.
My lord,
Chaudhary?
your lordship kindly go to the, my lord, record, my lord. I wrote a letter, my lord, specifically, your lordship has directed. Then, my lord, instruction on has come, my lord, written instruction. Your lordship kindly come to the page 1 of the written instruction, my lord,
Yes.
addressed to me, my lord.
Hmm.
In that detailed instruction, it is categorically stated, my lord, as per report submitted, DG West Siang, no work order has been issued either to any individual or agency from the office of DDSC Alo West Siang, also in pursuance of the letter dated 14/3/2022, issued by MLA cum advisor law justice preliminary for procuring the school uniform for the student of West Siang district, my lord. That is the letter, my lord.
Hmm.
And my lord, as because, my lord, this was my respondent number 4. Again, I asked to the department, he may do anything, my lord. Then next letter, your lordship has come, my lord, 1A.
1A.
Yes, my lord. Another person for the Deputy Director School of Education has said, my lord,
Hmm.
that no work order has been issued either any individual or agency from the office of DDSC West Siang district, also in pursuance of letter dated 14/3 to be issued by MLA cum advisor procurement will mean for the student government West Siang, my lord. So, my lord, as per this letter, my lord, no work order has been issued, my lord. It was directly go to the accounts of the, my lord, student. One thing is important, my lord. Earlier, I procured the letter, my lord.
Hmm.
I found one letter, my lord. So, record to them. Record to them.
Yes.
Lordship,
Hmm. What is
kindly
it?
come to the page 30, my lord. My lord, original record is available, my lord. Dear my lord, whole record. We take this, my lord. Your lordship kindly see, my lord, page 30, my lord.
Yes.
In pursuance of the Honorable Guwahati High Court of 29 that considering his own request for release of his of DDSA, Alo Dokenkato is hereby stand released from DDSA.
Let me argue my case. I have got some other points to.
And my lord, I have a some.
Yes.
Mr. Sundar, you've seen this letter.
I have not seen.
Own request to be released. What more is required?
Deputy Commissioner has said, my lord.
My lord, let me place my case.
And one thing, my lord, I want to produce some judgment also, my lord.
Let me argue
Let him
my
argue
case
first.
first, my lord.
You see this letter? Mr. Mazumdar,
My lord,
have a look at this. Transfer matter, writ appeal. What is the scope of interference? We found some merit in your argument regarding that letter. Now that doesn't survive. Thereafter, what is to be done?
This I'll have to take instruction. I'll place it before lordship, but let me place my case. 2-3 points I want to argue before lordship. Lordship will kindly allow me. My lord, may I kindly turn to page 123 for a moment. I'll just take 5 minutes, and I'll satisfy your lordship.
Yes.
Page 123 is the letter. My lord, is the letter from, he is also an MLA, Kento Jinimani. He writes, my lord, this letter. Hope this letter finds you in good health and spirit. Mr. Swenson is a petty contractor from Raglam village
Yes.
and very sincere and dedicated towards work. As you know, the Department of Education has released 27 lakhs for purchasing of school uniform, which is now pending disposal for award. As such, it is requested that the said work may be awarded to Mr. Swenson from Raglam village at your earliest convenience.
This is just a recommendation in ignorance.
My lord.
That is all.
My lord, lordship, kindly bear with me. I'll satisfy your lordship, my lord. Down below, my lord, lordship, kindly see the minister writes, respond number 6, writes to me, DDSC Alo, I was DDSC Alo, for appropriate action.
Yes, appropriate.
This
You
was
could have written.
this was the request.
You could have written the appropriate action. I can't do anything. It goes directly into the count.
My lord, this is my stand in the writ petition that this request I did not concede.
No mela fight against the
My
minister,
lord,
sir.
kindly bear. There is one more material I'll just show. This
Yes.
is one request which I did not concede, and I dissatisfied the
Is
honorable
is
minister.
there an allegation of mala fight against the minister, please?
Yes, madam.
Read, please.
This is
Read.
number 1.
Read the mala fight allegation first.
Allegation, my lord. Lordship will kindly bear this so far as this is concerned, my lord. Lordship will kindly see paragraph 10 of my writ petition, my lord.
Yes.
Allegations are very, very direct, my lord. My lord, paragraph 10 at page 61, my lord. This paragraph contains all the allegations of malafide, my lord. That the petitioner begs to state that perusal of the file noting reveals, because all these file noting I got after I filed an application on the RTI. Before that, I did not know. Reveals that Sri Alpha Sharing, who is member of Legislative Assembly herein referred to as MLA only of Diran, West Coming, and also advisor Public Works Department, had put up a UO note dated 2/11/21 proposing the transfer of the private hospital numbers 5 as DDSC Daporijo or as DDSC in any other district against vacant post. Lordship will kindly note, the respondent number 5 was required to be posted to some other place. This is what I've said here. It is further revealed that on 23/5/2022, the department had put up a file of 11 officers for consideration of their transfer and posting to different places. It is perusal of the file noting further reveals that none of the proposed transfer was in public interest, but on the basis of your notes made by MLS and other political functionaries, except for 3, namely so and so, so and so, so and so. Next paragraph. It is further revealed that the proposal for transfer of the private matter was put up on the basis of a UO note by Purpa Sharing Advisor PWD against any anticipated vacancy. It is also revealed that the transfer of since so and so was put up on the file of the basis of UO note of Kento Rina, who is MLA of Lower Siang, etc., etc. Now, Lordship, can you see this next line? For transfer of one seat, Tage Kakki, who was serving as DDSC, Likavali to DDSC headquarters, that is Itanagar. Then I skip this, my lord. Then Lordship will kindly see the next page 64, my lord. Page 64, my lord. That the file noting dated 28/6/2022 reveals that proposal was made by Sri So and advisor Honorable Minister Education for transfer of Sri Tage Kaki, who was serving as DDSC Lower Siang, as DDSC at Director of Secondary Education Itanagar in place of so. Then next paragraph. It further revealed that file noting reveals that thereafter a note dated 21/7/2022 was put up by the Honorable Minister himself, by which transfer and posting of 4 DDSCs and principal as was approved. And the private respondent was transferred from GHSS Yomcha and posted at DDSC West Siang district in place of petitioner. Well, I'll show from that 11 officers were concerned. My name was not there. And this respondent number 5 was required to be posted to some other place. It is because of the minister's note that I was brought here. Then, my lord, the next paragraph, my lord. It is most humbly stated that though the file noting dated so and so reveals the transfer of the petitioner as DDSC Director of Secondary Division has been done in extraneous consideration to accommodate private individuals and not in public interest, and the remarks made in the file noting is the transfer of the petitioner is just an eyewash. Inasmuch as by note dated so and so, the name of Sri Tage Kaki was earlier proposed to be transferred as DDSC Itanagar. However, the same had been changed at the ministerial level. It is further submitted that there is neither a single note put up by the officials of the department requiring the need and assistance of the petitioner service and experience in manning the directorate of secondary education, nor a whisper made in the file noting for transfer and posting of the petitioner from DDSC Alo, West Siang district, inasmuch as the petitioner was never considered for transfer to DDSC Itanagar by the department, as petitioner has joined as DDSC Alo only on 4/5/21. And I'm retiring in 1 year's time from now. I wanted to come to my village, my home district. Then, my lord, should you kindly see para 16 at page 69, my lord. Direct allegation, my lord. Para 16 at page 69, my lord. That the petitioner begs to state that during the pendency of his representation under consideration, he realized that his transfer order is being executed by respondent number 6 for the reason that he did not succumb to his respondent number 6's order demanding illegal and undue favor in the matter of award of supply of school uniforms to one Sri so on the recommendation of local MLA of West Siang district. In this regard, it is stated that a letter dated so from the Honorable MLA come advisor so bearing with signature of the respondent number 6 for appropriate action was received by the petitioner, wherein he was directed to award the work of school uniforms to one Sri so village amounting to rupees 27 lakhs only. Whereas, as per the prescribed norms and guidelines by Modi government, followed by state government, the amount was as sanctioned from the uniforms has to be directly transferred in the account of students. That is popularly known as direct benefit transfer, DBT in short. For transparency in utilization of public money as such, petitioner had denied to award the work, that is supply of uniforms to any private individual by way of illegal means. Thus, from the file notings and records, it is apparently clear that the proposal for the transfer of the petitioner was never taken up by the department concerned of the petitioner, but the file was called back by the respondent number 6 himself, that is the minister, my lord, and to wreak the vengeance, he himself proposed, recommended, and finalized for transfer of the petitioner. That too, when petitioner has even not completed the normal tenure, and also when the fact remains that the respondent number 6 himself has brought the petitioner as DDSC Alo, considering the representation of the petitioner that he needs to take care of his old and ailing mother, and he is on the verge of retirement. My lord, may kindly see down one thing, my lord. This is the process that was started, page 95, my lord. There are names of 11 persons who were considered for transfer. Now, page 95, it starts. Page 96, serial number 6, lord, you will find the name of respondent number 5, who was proposed to be transferred from West Siang, Omcha, second row, my lord, column, and fifth column is Daporijo, where he was sought to be transferred. And he is there for 34 years now, till today. He has served 34 years in the same place. He wants to remain in the same place. 34 years, my lord.
Where have you mentioned this fact?
My lord, yes. Clearly mentioned. I'm arguing from the pleadings now. It is an admitted fact, my lord.
Earlier, he was in school, my lord.
Maybe.
Yes.
My lord, I'll show that 34 years. Now, my lord, also kindly see, these 11 officers were there whose cases
In
were
the
being considered for transfer.
proposal for
Respondent number, yes. My lord, respondent number 5's name appears at page 96. He was proposed to be transferred from Omcha, again, same district, my lord, West Siang, to another place that is called Daporijo, again, West Siang. Now, jumping over that, he has been brought to my place. Now, lord, will you kindly see, this file notice continued, page 105, my lord. So far as the place where I am posted now, Itanagar, it is the name of Tage on top, Lordship, you kindly see. President Principal of GHSS Telam as DDSC Likabali Lower District and say Tage Kaki as DDSC as Directorate of Secondary Education, Itanagar, name is not mentioned, Ita head, Itanagar, is put up again for approval, please. Now the proposal was for placing one Mr. Kaki, Tage Kaki to Itanagar, where I have been brought now. Now, next, my lord, everything changes, just below that. Transfer and posting of following DDSC principal are approved as mentioned. Proposal was to bring Kaki in my place. Now, Lord, you kindly see the changes. Tage Kaki has been now taken to Yomcha, where the respondent 5 was there. Serial number 3, I am there. I have been transferred to Itanagar. And serial number 4, this respondent 5 from Yomcha to West Siang, same district as DDSC. Everything has been done at this stage by the minister. He called himself and he made the note himself. Now, where my lordship knows that judgment of the 1969 Supreme Court Patta 4 by Lord that Kane Commissioner's case, where the Honorable Supreme Court has said if the power has been given to a particular authority to be exercised, if the power is also exercised by the Chief Minister or the Honorable Minister, then there is clearly, my lord, non-application of mind because there is no administrative exigency in such cases. These being the position, my lord, and after in the first round of litigation, when I was directed to file a representation against the transporter I filed, I specifically raised the plea of this my mother's illness, number 1, number 2, this malafide, my lord. Nothing has been mentioned in the speaking order. These 2 points have been totally ignored. This with the speaking order, lord, will find at page 121. In the speaking order, my lord, nothing has been discussed at page 122, only one thing. My lord, should kindly see page 122. This is how the speaking order has been passed. First, the second paragraph, my lord, whereas as per records, the date of birth of the appellant, my lord, Duken Kato so is 1st March 1965. Hence, he has more than 2 years service career left for attaining superannuation. Now he's left with only 1 year, my lord, for retirement. Therefore, he can be transferred anywhere at this stage. Further, the personal and domestic ground can be accommodated to the extent possible in public interest. Whereas, in the meantime, WT message number so has been received from the Deputy Commissioner Alo that in persons of government order number dated Sri Yadav Angu, that is Ratana 5, principal has joined his duty as DDSC on 1/8/2022. Hence, taking into account the cumulative position as examined and observed above, and more particularly when the transfer of petitioner Sri so has been effected in the interest of public service and for the administrative expenses, prayer for retention made in representation so cannot be considered. Now, Lord, should you kindly see the representation which I made after the disposal of the writ petition, my lord. Page 118 it starts. I have specifically highlighted at page 119 about the wreath I have earned for my deeds, my lord. 3 things I have done. School uniform award I did not do. Then transfer of one gentleman from one place to another I did not concede. And thirdly, my lord, another aspect of transfer order, which I have given in the list of dates. Now, page 119 of says, my lord, the other ground on which transfer details order so was assailed was that the transfer order was not issued in public interest inasmuch as the file notice procured by my client revealed that transfer of my client was never put up or mooted on file by any of the departmental authorities who are the authorized person to decide upon which official is to be posted at a particular place in public interest. In fact, the file notice revealed that all the cases for consideration of transfer was put up on file on the basis of EU notes put up by the MLS and other political functionaries, except 3 who had made self-representation for their transfer. The next paragraph, I highlighted the ailment of my 90-year-old mother. Now, all these were not considered in the speaking order. I mean, my submission before Lordship is very clear. It is absolutely clear that for these 3 acts on by my client, my lord, he has earned the wrath of the Honorable Minister, respondent number 6. And I'm trying to relate it to the transfer order because when there was nothing Then the department never wanted me to be transferred from this place to there. Now suddenly my name comes in. Why? Because the minister wants that I should go out from there because I'm not conceding to his request from time to time. And this I have clearly shown, my lord. Page 123 about the school uniform. Page 199 about another transfer order. He's sought a transfer of another person. Lord, should kindly see page 199. Let me point out that also, my lord. Page 199, my lord. This was the letter by me to the commissioner saying that I cannot concede to such requests. Page 200, my lord, just the third page from the bottom. Importantly, one more case regarding retention of, say, Ripin Taba, contractual TGT under ISA in the establishment of DTC Lower Siang, for which correspondence has already been made to your good self by number so and so. Moreover, only teachers in the education department are seeking transfer or joining posting ground. Why not the employees of other departments? For joint posting, only teachers are adjusted with employees of various departments. In this instance case, why the husband of the incumbent contractual teacher can't be seek joint posting ground so and so? Therefore, an appeal is hereby made to your good self kindly to revisit the transfer order number cited above and do the needful action authority.
This is
Thereby-
hardly, Mr. Muzumdar, this is hardly anything. This is just official communications with.
My lord, Lordship, may kindly see for this page 92, my lord.
Yes.
Page 92, my lord.
Hmm.
This is again by one MLA. This is regarding the appointment of C so and so principal as DDAC either in upper subordinate ministry or so and so. It is learned that present incumbent so and so is retiring on superannuation on so and so, whereby the post of DDC Subansri will be vacant. In this regard, the undersigned thereby recommended Sri Yadav Angu so and so Yomcha to be appointed and posted as DDAC upper subordinate. It is understood that Sri so and so in his 35 years of service has served in various capacities like so and so, but all in West Siang, my lord. Further, he is of the dedicated and hardworking and with vast experience in the Department of Education. In view of the above, HM Honorable Minister Education is requested to consider for appointment and posting of Sri Yadav Angu. That is number 5. After the superannuation of the present incumbent as December 2021. In this appointment as DDSC upper subordinate is not possible, he may be posted as DDSC in any other. Everything is at the instance of response number 6, man.
Yes.
Just one more thing I'll point out. Page 198 for a moment, I'll trouble your lordships. This is a request by one Mr. Ripin Taba to the Honorable Minister.
You already read.
Well,
about Ripin Taba.
this I have not read now. This is different. So at last,
Same person who is referred to in your letter to the
yes, there,
commissioner.
yes, this is with regard to transfer of one person, retention of one person in a particular place. He is working in one place, drawing his salary from another place. So the request was that he should be retained. My client said, my lord, no, I cannot do that because it is not permissible. So for this school uniform matter and this matter, my lord, the response number 6 minister was against me. So he wanted to ensure that by a special note put up by him, when the department never wanted me to be transferred, I was transferred.
Right.
Now, so far as the almost single judge is concerned, my lord, what will you kindly see one thing, my lord? The finding.
Yes.
What is the finding of the almost single judge? Page 45, my lord, para 16. This paragraph will alone show, my lord, how the allegations of malafide was dealt with. Lordship has got, my lord, page 45, para 16. Apart from the limited nature and scope of judicial review available to this court vis-a-vis the impugned order of transfer as highlighted above, it is equally settled position of law that the suitability of an employee for posting at a particular place by making whatever the assessment is within the domain of the employer, and it is not for this court to enter into that arena, which is exclusive domain of the employer. In the instant case, I find that the respondent authorities have made some assessment as regards the suitability of posting of the employees, including the petitioner, that is the respondent number 5. From the record, it is found that on an assessment made by the respondent authority, the petitioner has been found to be suitable for posting as DDSC, DSC Itanagar, having regard to his experience. Once the employer has made some assessment on suitability of an employee for posting at a particular place, it is not for this court to substitute the assessment made, as the court does not have the expertise to assess the suitability of an employee to be posted at a particular place, nor it is within the domain of this court, or it is the function of this court to enter into the arena of assessment of suitability of an employee for posting at a particular place. The argument advanced by the learned senior counsel for the petitioner, that is so without any objective assessment made by the is rejected. And my submission in this regard is, my lord, the only finding by the honorable single judge is that there was some assessment made. I'll show, my lord, there was no assessment. Even if the, my lord, assuming that record says some assessment was made between two of us, my lord, Doctor will kindly see, once the initiation of the process for transfer is mala fide, after that, even if some assessment is made, my lord, it will not lose the character of being invalid for being actuated by mala fide, my lord. And Lord will kindly see the noting whereby this exercise was shown to have been done. This is the only thing, my lord. Page 105. Page 105. Page 105, my lord, serial number 3 in the table, my lord, right inside the last column, my lord. The department is in need of an experienced senior DDSC at DSC office. The service of Sri Duken Kato, that is the apparent, my lord, DDSC Alo, will be of great assistance to the department. His service and experiences are required by the headquarters.
So that is serious appreciation.
My
for
lord,
your
serious,
client.
my lord, I never wanted this kind of compliment. This
They
was,
are giving.
my lord, this was in my humble submission, my lord. Your lordship will always know why these wordings were used to show bona fide and to show that I am a very good person. When I am suffering because of the transfer order, these compliments are very clear that these are used only for the purpose of justifying the transfer and nothing else. And when the department never wanted, it is the minister who has, I have made specific allegation that it is the respondent number 6 who called for the file and then makes this note, my lord, file note, of UO note. So, my lord, yesterday, my lord, one submission was made by my learned friend appearing for the private respondent that in one paragraph it is mentioned that I have abandoned the plea of mala fide, my lord. My lord, my lordship will kindly see once again what was that submission statement, my lord. There are 14 at page 44 because I've got to make a reply to that, my lord. Page 44, para 14, my lord. In the instant case, learned senior counsel for the petitioner has made it very clear at the very outset that though he has received several letters from the respondent number 6, including letter dated 14/3/2022, written by the MLA cum advisor law, justice and parliamentary affairs government of Arunachal Pradesh, and endorsed by respondent number 6, there is no material to show that it is because of these letters the petitioner has been transferred to DDSC office, Itanagar, so as to able to establish mala fide against the respondent authorities. Neither any argument of the impugn order, transfer order having been issued in violation of any stated rules have been advanced. And so far as the first observation of the honorable signature is concerned, my lord, what on behalf of the appellant was said is that letters apparently doesn't show anything. But otherwise, argument all throughout attack to the transfer order is on the basis of allegations of mala fide, my lord. I have given several materials. And even assuming, my lord, this was a concession that I am abandoning this argument, my lord, there is a judgment of the Supreme Court which says, my lord, that appeal being a continuation of the appeal, my lord, even if there is an abandonment, I can always take the plea, my lord. This is 2007, volume 7, SSC final, page 206. Para 22, Lordship may kindly see. Lordship's got manner. Para 22. The learned additional Solicitor General has submitted that Since learned counsel for the respondent writ petitioner has already abandoned the plea of perversity, that is, that the finding is perverse, the same is not open for learned counsel for the respondent writ petitioner to press again before the division bench of the High Court. Since the writ appeal is in continuation of the original order passed in writ jurisdiction by the learned single judge, it cannot operate as an estoppel against learned counsel for the respondent to press the same. If the finding recorded by the inquiring officer is not sound and it relates to perversity, then the appellate court in writ appeal cannot stop the counsel from raising the plea. More so, the division bench, after considering the matter, has found that the whole approach was perverse because the respondent alone has been made a scapegoat. When the decision of all the three committees was unanimous, etc., my lord, we can skip all this. So, my lord, records overwhelmingly make it very clear, my lord, that the department never mooted any proposal for transfer of the present petitioner, my lord. And so far as the place where the petitioner has now been posted, one Mr. Kakki was proposed by the department. And so far as the present respondent number 5 is concerned, his case was also under consideration for a transfer. But the appellant was never in contemplation of the department. In the file noting, we make it very clear. Now it is respondent number 6 who suddenly brings in. And why I am trying to relate, because my lord, directly nobody can prove my lord mala fide. It is from the surrounding circumstances one has to establish my lord the allegations of mala fide. And for that, my lord, I am relying on another judgment of the Honorable Supreme Court, my lord. That is 2020, volume 3, SSC, page 86.
Yes.
My lord. Yes. Well, para 19, my lord. Para 19. Lordship has got, my lord.
Yes.
In a judgment in Union of India versus Ashok Kumar, it has been held that allegations of mala fide are often more easily made than proved. And the very seriousness of such allegations demands proof of higher order of credibility. The court held as under. Doubtless, he who seeks to invalidate or nullify any act or order must establish the charge of bad faith, an abuse or a misuse by the authority of its powers. While the indirect motive or purpose or bad faith or personal ill will is not to be held established except on clear proof thereof, it is obviously difficult to establish the state of a man's mind, for that is what the employee has to establish in his case, though this may sometimes be done. The difficulty is not lessened when one has to establish that a person apparently acting on the legitimate exercise of power has, in fact, been acting mala fide in the sense of pursuing an illegitimate aim. It is not the law that mala fides in the sense of improper motive should be established only by direct evidence, but it must be discernible from the order impugned or must be shown from the established surrounding factors which preceded the order. If bad faith would vitiate the order, the same can, in our opinion, be deduced as a reasonable and inescapable inference from proved facts. It cannot be overlooked that the burden of establishing mala fides is very heavy on the person who alleges it. Well, these things are there. If Roeper case has been made. So, my submission is, my lord, there are ample materials to show that the preceding facts were such where I've earned definitely, my lord, the wrath of the minister. And I have made a specific allegation. Minister did not respond to that. That the file was called by himself and he made the UO note himself. And department never wanted my transfer, my lord. And I'm retiring in 1 year's time from now, my lord.
Okay.
So that means the position, my lord.
Lordship, ask my lord, your lordship kindly go to the my lord representation that.
What was the original proposal of transfer? Whether his name was there or not?
My lord?
What was the original proposal of transfer?
Yes, my lord.
Whether his name was there or not?
Lordship, kindly come to the my lord page, my lord. 103, my lord.
Yes. Yes.
Yes, my lord. The file was recalled by Honorable Minister of Education.
Recalled,
Yes, my
we,
submitted.
Ms.
Yes, my lord.
Chaudhary, original proposal.
Yes, my lord.
There is that.
Yes, my lord.
No. Page 95.
Yes, my lord.
Yes.
Transparent posting of DDSA, my lord.
Was the name of the appellant there in this list?
That is not available, my lord.
Hmm?
That is not available, my lord. Document cutoff's name, my lord. No.
It's not available, is my lord.
It is not there, right?
Yeah, 97, my lord. From the repetition I have submitted, my lord. I have to go all the, my lord. Yes. The record, my lord.
Mr. Chaudhary, that is a specific ground taken by him,
Yes, my lord.
that his name was not there in the original list, original proposal, right?
Yes, my lord.
How many years the respondent, number 6 is?
Earlier he was the principal, my lord.
In the same district, Mr. Chaudhary,
Yes, my lord. Principal
34
of the
years.
school, my
same
lord.
district.
Yes, my lord. And-
How many years?
Hello, as a principal of the school, my lord, normally principal were never transferred, my lord, of the school. Your lordship. when
How
they-
many years of total service he has given in the same district?
As a principal, my lord, he may be. some-
35 years.
I have
34
to
years.
go, I have to go through all these things, my lord.
So then why you are standing here
My
if you are
lord,
not aware of
my
these
lord,
things?
As a principal of the school, my lord,
Mr. Chaudhary, what is this argument? I have to go through this. Then why you are briefed here
Yes.
to argue the matter on behalf of the state?
yes, my lord. As a principal of the school, he was taken, my lord, earlier. If your lordship,
As an employee of the education department,
Yes.
how many years he has served in this same district? At the same place?
yes, my lord, lordship has asked me this question, my lord.
Yes.
My humble submission before your lordship, is before he coming to that place, my lord, he was the principal of the school, my lord.
Is our question very difficult to discern, Mr. Chaudhary?
Yes, my lord.
Yes.
Yes, my lord. Your lordship kindly come to the, my lord. Record, I have to go to the record of the that person also. I have taken the document original file. I have to take the file of the other person.
This is a pleading, Mr. Chaudhary, pleading, part of the pleading.
Yes,
Have you read the pleadings?
yes, ma'am. That is available, my lord, as because state has not filed the affidavit. So I have to take the instruction, ma'am, that instruction.
State did not file the affidavit in the single bench.
Yes, my lord, no file, my lord.
This was
Then-
not
That
denied.
is why my. I am
Then these are uncontroverted allegations.
And
Did the minister file a reply?
minister, my lord,
No, obviously.
obviously, my lord, whether notice has been gone to the ministers or not, I do not know, my lord. Because he has personally made the party of the minister, my lord.
The
Malad-
notice was served to the minister, Mr.
Yes, ma'am.
Mazumdar.
The minister
Oh.
doesn't appear in this case. Your lordships are aware. ma'am.
Because there is an
It is
allegation,
too
my lord.
late in the day
He
to
is
say
the
that
necessary
whether he
party.
appeared.
He has been implicated.
I want to submit.
He
the-
has been implicated, Mr. Chaudhary.
Yes, my lord.
The minister is a party.
Minister is
in
a
the-
party, my lord, my
Yes.
submission for your lordship there. There is a Malafide, by name minister was made as a
What
party. in the
prevented
single
you,
bench.
Ms. Chaudhary,
Yes, sir.
what prevented you from filing the reply?
My lord, in single bench, my.
Yes,
I am not appearing, my lord. I am appearing.
that is no argument, sir.
Yes, my lord. My humble submission is something different, my lord. My submission before your lordship is that by name minister was a party respondent in this case. Whether notice has been accepted for the minister by the council, standing council or not, I do not know, my lord. Of the, at
So
that time.
your ignorance should be a ground to postpone the matter. That's right.
My lord,
Your ignorance should be a ground to postpone the matter.
lordship kindly, I take the instruction, also take the file, like Duken Kato, I said, take the file of the other persons also.
Why should we give you that
Because-
time?
Because my lord, affidavit was not filed.
Why didn't you file it, sir?
That's my lord.
What prevented you from doing so?
In repetition, that was not filed, my lord. That is why, my lord. I also kindly grant me some time, my lord. I shall take the file of that person also, my lord. Personal file, then I can know how many years he is available on that place.
he has made a specific allegation 35 years.
That's fine.
Mr. Das,
Yes, I'm sorry.
what's your instruction?
I'm sorry.
How many years has your client served? Hmm?
34. 34 years.
34, admitted.
That's true, my lord. Your lordship is right. How can I say that I have not served? That's a point.
This
My lord,
plea which is coming from the
no,
state
I'm
is
sorry.
absolutely pathetic.
No,
You would
this is-
say.
Well, it's a, the state will have to say, my lord. My lord, when the matter before the learned single judge,
Yes,
the point which was taken.
we are
And the, no, I
absolutely
noted
not
that-
satisfied, Mr. Das.
your lordship.
This is malified on the face of the record.
No, there are 2 points.
Yes.
First point which my learned friend has taken is 14/3/2022. That is not there. My lord will kindly see.
There are 9 of the impugned order.
There are 9 of the.
Impugned order. Does it now require any more deliberation even?
9. At page 42, my lord. 9.
Yes,
So and so learned time while not disputed content period of facts, period repetition. Impugn transferred and
So-
include.
the facts pleaded in the red petition are not disputed. What more was wanted, sir?
But my lord will kindly see the ground of the transfer, my lord. No, my lord will kindly see, my lord was see his representation. I'm sorry to trouble your lordship. Kindly see my learned friend read the representation. He has not read the representation, my lord, page 88.
Yes,
Where he said in the representation, malafide has been alleged in the representation. Now, if in the representation, malafide has been, my lord, alleged, I have nothing to say, my lord. And
the
disposal.
malafides are alleged in the red petition, sir.
No,
It's a fact.
No,
You can't, that is not disputed. Education department, the state
But-
admits what the petitioner says.
but malafide, he has given up, my lord. That's what I am
No,
saying, my lord.
no. That's
Kindly
not given
see
up.
at
That is
page,
the manner-
page 44. my
manner
lord.
in which the argument has been dealt with. It so seems that the malafide has been given up, but it was never given up. It was not even denied. Where's the question of
No,
giving it up?
that's my lord, the government. My lord, kindly see what was his own trust of the cases in para 15.
Yes.
Kindly see para 15 is a trust of the
One
case.
person, a blue-eyed boy, serves 35 years and the other can't be permitted to remain with his mother even for 2 years.
My lord,
What
that's
is
my
this?
lord, my lord,
Sorry.
kindly
They
see
are
page-
not at all satisfied,
My
sir.
lord, kindly see page
Yes.
44, my lord. Para 15, my lord.
Your client should be sent to the farthest district of the Arunachal
My lord,
Pradesh.
that's your lordship. prerogative.
Absolutely no.
My
no.
lord, that's your lordship. I
This
can't say on. this
Inhuman way of dealing with employees.
I am, that I can't
Absolutely.
say, my lord. My lord,
Yes.
kindly see page 44,
I have
Yes.
never been to my home district in my
Kindly
entire
see-
career.
page 44, my lord.
First
Yes.
time I'm asking that I should be there with my mother.
But
Yes.
kindly see page 44, my lord.
Hmm.
The trust of the argument advanced by the learned senior counsel for the petitioner, therefore.
That is the conclusion of the learned single
No,
judge.
that's what.
There is no metal show that this, because of these letters, petition has been transferred. That is the conclusion. He is not giving it up.
No, the trust of the argument was that, my lord. Because he once 14/3/2022, other malafide.
What business does the minister have to write to the DDSE? Give him a total contradiction of the scheme which prevails.
No, I'm sorry, my lord. That was not done. Your lordship has seen the records, my lord.
Yes,
See the
not
records?
done is a different thing.
Yes.
The minister very well tried to do it.
That's not
It
the
was not
minister.
done. That is why he has been transferred.
No, that's not minister, my lord. With that.
He refused.
My
It has
lord,
been
kindly
transferred.
see 14/3/2022 letter. Your lordship.
All
want to
right,
see that
conclude
letter?
your argument, sir.
You have seen, your lordship has seen the letter. 14/3/2022.
Conclude your argument, sir. All right.
I
That's all the more big, stronger reason that when the scheme was direct transfer, what business did the minister have to write such kind of letter, recommendation?
But that recommendation was not exceeded to kindly see, my lord.
Ah.
That's your lordship want to see the records.
Mr. Das, we are saying that all the more stronger reason to accept what he says. The minister doesn't even know what is the mode of transfer,
My lord, will-
recommending grant of contract.
my lord will kindly see if your lordship is looking to that at page 90,
Yes,
that 92, your lordship has said that from page 90 95, your lordship has pointed the letter of 95 of that 95, page 95.
yes,
Your lordship, his name has not been shown
yes,
in that list.
yes. On recommendation, everything is recommendation. All transfers on recommendations, you notes. And in that proposal, he was nowhere there. Only because he doesn't exceed to the illegal demands
Kindly,
he sent out.
kindly see at page 95.
Yes, we've seen it.
95, Lordship has seen, his name doesn't appear.
Yes,
Now
then what
kindly
happened
see
overnight?
98, kindly see, page 98 down below. After
Yes.
that, superintendent may peruse and endorse the file to the competent authority for
Yes.
further necessary decision.
Hmm.
That was on 23/5/2022.
Yes,
Now, may like to endorse the file to higher authority to government for government decision through DAC, please. Now kindly see 145.
Hmm.
Department has received so many application UN note from the honorables for posting them so and so. Change for various district and proposal. So file may be endorsed to government for obtaining further orders as proposed.
Hmm.
Now your lordship will further go down. But it doesn't happen one day. Now it goes to at page 103. 103.
Yes.
Kindly see at page note number 165. 165, your lordship goes down below.
read page note
The
number
file, I'm sorry,
147.
147,
Yes. 47.
147.
What was the proposal of the
One-
director? was the
147
proposal
at
of
page
the director?
99, at page 99.
What was the proposal of the director for DDSC?
I'm reading that, my lord.
Right,
Note
yes, please.
147.
Yes.
For serial number 1 against the vacant post of so and so, Siang district from retirement of so and so, both the concerned honorable MLA have submitted joint UN note for transfer and posting of so and so. Serial number 2, Neoma Rina, principal so and so is one of the senior most principal department and deserve for the post. Serial number 8, Tomi Doka is one of the senior most so and so. Serial number 10 for so and so has given a UN note requesting for his confirmation and so and so. Except Sri Tani Tolam, who was promoted as principal during so and so and already served in 2 districts, East Siang and Pake Kesang, and so was promoted during 2. All others are newly promoted principal. May likely to endorse the file to so and so.
Yes.
Now, if your lordship goes further down,
He is
at
nowhere,
page-
the appellant is nowhere in picture.
I'm showing at page
Yes.
103, my lord. How it is.
Hmm. Hmm.
Page 103, kindly see, my lord. If your lordship goes down, note number 165.
Mr. Das, read the note number 145. Is it administrative exigency now?
145.
Yes.
The department has received so many applications in UN note from the honorables for posting them at DDSC of the district again retired chains of so and so various district as proposed as note number so file.
So does it now retain the character of administrative exigency in the interest of administration? So only on desires, nothing other than that.
But kindly see at 145, 165 has to be looked into it by your lordship. My lord.
Yeah, carry on, please.
165.
Yes.
Kindly see the file was recalled by the Honorable Minister Education at page 103, my lord,
Yes.
and submitted to advisor for obtaining decision for the rest proposal order number 152.
Hmm.
In the meantime, it is also informed that Srimati OA Borang Tak DDSC's secondary education has been transferred so and so. Now secondary education needs. So that particular post became vacant, my lord.
Hmm.
So when it became vacant, that definitely Dukan Kato's name cannot appear at page 95.
Hmm.
So this particular lady, my lord, that particular post has been become vacant. So now,
Issue is,
No.
Mr. Das, why can't your client be sent as a DSC Itanagar? What is the problem? Why can't your client be sent there? Where he has been sent?
no, that's the government decision, my lord. That's now, my lord, we kindly
Absolutely.
see. Now kindly see, now secondary education needs
Yes.
sincere and dedicated DDSC against her. Therefore, DDSC may like to suggest the name among the so and so. The deployment list of, so for the first time it has come, my lord. It is not at page 95. That post was still occupied by someone.
Yes.
That post, my lord, at page 95, your lordship has put specifically why that particular gentleman name, appellant name has not appeared. Now kindly see the note at 103 at 165. That lady was holding that post, my lord. Once she was transferred, my lord,
Hmm.
from that post, when it became vacant, my lord, then his name came, my lord.
Yes.
Then my lord, kindly see, therefore DSC may like to suggest the name among the DDSC posted at district. Deployment list of is placed at 104 ready reference. This hence file may be endorsed to advisor for obtaining decision of the government, please.
Yes.
So my lord, now kindly see at page 105.
Yes.
105, my lord. Kindly see at serial number 3, my lord.
Mm.
At 105. The
Yes.
transfer posting of so and so, 3, Dukan Kato. Dukan Kato Alo will be of great assistance to a department. His service and experience are required by the headquarters.
Yes.
Because once the post has become vacant, my lord, he is the senior most, that's why they seek a transfer. Because he is the most sincere, and kindly see, my lord, what is his representation, kindly see, my lord. Because my learned friend has specifically said before your lordship, in the representation, he has raised the point of malafide.
Read note number 171.
171.
Yes. Approved. Approval is of which proposal? When was the proposal?
The following posting of so and so are approved as
Approved.
mentioned below.
Approval of which proposal? Where is the proposal?
That's my lord, the records will reveal, my lord. How can
Had to be in this very noting.
I don't
Had
know,
to be in
that's
this
record.
noting.
My lord, which is not in the records, I will not say.
So
before your
there was
lordship,
no
my lord.
proposal at all, sir.
Yes, sir,
That's
I
what we are
can't say that,
telling
my
you.
lord.
Right from word go, that is what he is harping on. There is no proposal.
But
What
my
has he
lord-
approved?
But my lord, 165,
Yes.
kindly see, 165, 165 has to be read. 165 has to be read, with
Yes,
171, my lord.
Read.
Kindly see 165.
Mm.
The file was recalled by so and so and submitted to advisor for obtaining decision of the rest proposal order number 152. In the meantime, it is also in the meantime,
Mm.
it is also informed so and so has been transferred. So now second it needs sincere and so suggest the name among the so and so deployment list of so and so.
Mm.
So if 165 has to be read with 171, my
Where
lord.
is the proposal, gentlemen?
For
of this
Dukan
posting?
Kato, my lord.
Where is the proposal?
That my government will say, my lord.
All right,
Well,
Mr.
my
Chaudhary.
record has to reveal, my lord.
Monday, original record. Mr. Chaudhary shall keep the original record pertaining to the transfer postings in question available with the officer in charge on the next date list on Monday. Return this, return.
Deeply obliged.
But can it be Tuesday, madam?
Tuesday, all right.
Deeply obliged, man.
Record वापस दीजिए.
Deeply.
Yes.
Item number 9.
Please proceed.
Old pension scheme, admit issue notice, connect with so and so. Number of the other similar appeals.
Yes, ma'am, that is 163 oblique 2023.
Item number 11.
My lord, after condemnation of delay, my lord, first time it has come before lordship, my lord.
The remand is with consent. How can it be subject to appeal?
Lordship, I am.
Oh, no, my lord. In respect of that order, my lord. So far consent is concerned, my lord.
Hmm.
By this, in the review application or the writ appeal, that your lordship has said, my lord.
Yes.
Yes. My lord, that part is in respect of that part, my lord, there is no consent, my lord. Lordship will kindly have a look at, my lord.
Yes. Para 4.
Yes, my lord,
Yes.
164, my lord, first judgment, my lord.
Hmm.
Last paragraph. At this juncture, this court also gives a caveat
that since an authority had already taken a decision by applying his mind, the department, if so wishes to go ahead, the matter disciplinary authority has to be a different entity of the same like.
Yes.
With regard to same, my lord, there was no concern, my lord. Otherwise, my lord, we agreed to, my lord. So far remanding back is concerned, my lord.
Yes, what are you saying?
A memo of appeal has not been served to us.
Already serve a copy of the memo of the council for the plan to provide copy of the memo of appeal to learned council representing the respondents.
So will come up, my lord.
List for admission after 1 week.
Item number 15.
There is an adjournment slip. Who has circulated the,
My lord,
There's-
may I pray, my lord? We have got 4 prayers in this petition, my lord.
there's an adjournment slip in this matter. Who served? We don't know. Who has given the
Actually, my
adjournment?
lord, it was done from our side. Since it's a matter of 16, my lord, I thought.
Normally, we don't expect
Yes,
Ms.
yes.
Chaudhary to.
Yes,
finish the
see,
slips.
my lord, my limited prayer is, my lord, we have got 4-fold prayer. Let the authority consider, my lord.
It's for them to,
Consider করি বলে বলতে হবে না, তাহলে consider করো। Slightly delicate matters, my lord. I think best authority, let them, my lord, pass an order in which case we'll know the reasons. My lord, we are all, my lord, Botley tea factory owners. Well, certain restrictions have been imposed.
who is there? Who has filed the adjournment slip
Actually, it was filed on our behalf, my lord.
for your behalf?
Yes, yes.
Then he wouldn't be prepared, obviously.
No, I have told him, my lord. Anyway, my lord, it's up to my lord.
List on 27 July as jointly prayed.
Instead of 27, could be on the following Monday, my lord, 27. I may not be there.
August, 2nd August.
My lord, I'm deeply obliged.
Item number 16.
What is this PIL about?
Last week, this matter, we have filed our affidavit.
You file?
Reply filed by the respondents.
Yes, yes.
So Dr. I pray for date for hearing.
It's listed for hearing.
Transmission hearing.
Like Mr. Nayak submits that he needs some time to prepare and argue the matter. List up to 2 weeks.
Item number 17.
Same matter.
In this case, Lord, there.
Shiksha.
Other
Serve
side has
Shiksha.
not yet filed reply, Lord.
You have to file. You have to file reply.
I have filed, Lord.
You filed.
Their reply is not yet.
Not there. Okay, affidavit and reply is not necessary. None present for the petitioner. List after 2 weeks.
Item number 19.
Yeah, Anganwadi worker. Litigation.
In this case, my lord, record from the office was confirmed, so there it is.
Madam, you have the record?
I have received the photostat record, lordship, as per present CDPO. Original record is not found, but as per our government office, lordship, earlier sent back to the CDPO. So I need some time to verify.
Mr. Bora, MS Bora, praise for MS granted some more time to keep the original records. List after 4 weeks.
Date may be fixed, ma'am.
Deeply obliged, lordship.
Supplementary list, item 36.
Yes, Mr. Mehdi. What is the matter about?
My lord, this is this matter, my lord, appeal, my lord,
Hmm.
against the judgment of adjournments, my lord.
Yes.
Here, my lord, this specifically, my
Yeah,
lord,
that's
this,
position.
judgment is, my lord, from 211, my lord.
Hmm.
And my lord, this so far, this paragraph 15 is concerned, my lord.
Yes.
15 is concerned, my lord, is lastly, the issue whether the landowner would be entitled to payment of interest from the date of possession, taking possession till the judgment of reference court in view of the land value being nil. It may be said that although the collector did not award any compensation award value in the award number 1 of 2012, but the reference court LA so and so found that the landowner is entitled to value of 25% per square feet was given to the similar
So
situation.
the order of the collector stands merged in the order of the reference court.
My lord,
The order of the collector would stand merged in the order of the reference court.
here what happened, my lord? This, my lord, initially there is a order of the reference court. Reference court order speaks, my lord. This reference court, this relevant portion, my lord, I'm reading, my lord.
Hmm.
The page, my lord, 115, my lord. No, page, my lord, not one. The page, my lord, 124, my lord.
Hmm.
The district collector, the deputy scholarship, so and so, my lord, day after, my lord, this and the collectors will sell intimate elements so and so, my lord. Next verse, my lord.
Yeah.
The said amount shall be paid by the general manager so and so within 3 months from the date of receiving intimation of district collector so and in failing to pay the market land value the landowner shall be entitled to interest 34 under section 34 LA Act with effect from 17 January 2017 till full and final payment. This my lord order was my lord so far 37 of 34 section my lord, this statutory program interest my lord, it will be from the effect from 17 January 2017.
Hmm.
It is there, my lord. But
Yes.
when my lord subsequently what happened, my lord, this order, my lord, there's another part was there, my lord. They went for execution, my lord. The execution court, my lord, this that part, my lord, 23(1)(a), my lord, this that part, my lord, sorry, my lord, that interest was given, my lord. But the execution court said it is open for the petitioner to place their grievances under section 34, the statutory interest from the date of possession of the land, my lord. From the date here, my lord, says, my lord, from the date of effect of this order, my lord. My lord, from here, my lord, the reference court, my lord. My lord, the deputy collector, my thereafter, my lord, the pass an order. This order, my lord, is my lord. This order is my lord. This order is my lord, page 154, my lord, 154. The relevant portion, my lord, relevant portion 156. Hence, in the view of the above instruction, I am satisfied the award petitioner instant case, statutory interest 34 Act assessment interest so shall be made from the date of possession, possession 4/3/2013. And 9% for a period of 1 year, 15% for the expiry of the 1 year subsequent till that so and so, and 17/1/2017. My lord, here, my lord, this that portion, my lord, what the reference court says, my lord, from the date of judgment, if not paid, my lord, it is required to pay the under section statutory interest, my lord. Here, the district collector, my lord, said no. From the date of possession. Yeah. Another case, my lord, this.
After the reference position will be like that.
No, this another your lordship one in adjournments, my lord.
All right, issue notice to
My
the
lord, here another your lordship in admitted same issue, my lord, in another appeal, my lord, adjournments, my lord, on 13th of June, my lord.
There's a delay, my lord, 113 days, 30 days, my lord. So, my lord, this my stay petition was not hard at that.
Issue notice to the respondents.
My lord,
Notice
problem-
issued on the prayer for interim relief also. After hearing only will.
my lord, another thing, this case, my lord, is in section 26 of this month before the adjournments, my lord.
Hmm.
The author of this, my lord, this judgment, my lord, the present case, single, Honorable Justice Nelson is there, my lord.
Hmm.
So that matter will be taken by them, my lord, but his, whatever views expressed in single bench, my lord.
So then you can make an application in that case.
Yes, ma'am.
We'll transfer it here.
Yes, ma'am.
Make an application.
Yes, my lord.
Rule is, and steps for service be taken in 7 days. Rule is made returnable in 6 weeks.
Well, may I pray, my lord, this appeal also heard along with this appeal, my lord. So, my lord, issue is same, my lord.
Still, as on date, even service is not affected. That will cause a huge problem. Those litigants, where they will find out the date.
My lord, there's so, my lord,
You file a proper application, we'll see that after.
my lord, paper publication is required, my lord, because so many clients.
And since the number of private respondents is large, the Appellant Union of India is permitted to effect service by publication, proper application. Upon application being moved under order by Rule 20, the notices be provided thusly for publication in 2 newspapers having wide circulation in the area in question. One in English language and one in Mizo language.
Yes.
Item number 37.
May it please the lordship. Challenge the validity of the proposed amended rule, my lord, but the medical colleges rules of 2017. The issue is down to this, my lord, that whether the 10% EWS quota is to be restricted to only 6 of the 12 medical colleges of Assam or to be to the entire 12, my lord.
Let the state respond.
My lord, that is there. And my lord, the state, my lord, I have indicated that in another writ petition which was filed originally before the learned single judge, my lord, on the cabinet decision, challenging the then cabinet decision.
Yes.
Repeated assurances were given to the court, my lord, that there is the petitioner's apprehensions are unfounded. Lordship will kindly see, my lord, on 30th of June, 4th of July, and again on, my lord, 13th. Specific instruction came from the state, my lord, that there is no such planning, there is no such, the apprehension is unfounded. It is recorded in the order. In fact, the learned single judge, there is an observation that if there is any admission made, any process starts, it will be made in terms of the existing.
So that protection is already given.
No, that is there, but
Then-
after the notification, my lord, the scenario would change. What we would pray, my lord, is that 10% of the seats under the
This
quota-
we can't judge in a matter.
in the
when
other
the
6
Statute is challenged, there can't be a stay, sir.
No, the
There has to
future
be a
of,
final adjudication.
no, that is correct, my lord, but let them take the instruction or file whatever, my lord, so that because
In the other
counseling
case,
will
we are
start.
filing affidavit tomorrow and Monday is the date fixed for disposal.
So,
But my lord, the notification is not challenged in that petition. The notification is
that is why we'll adjudicate.
challenged.
Issue notice, Ms. Saikia, Advocate General Ms. Saikia puts in appearance on behalf of all respondents. Copy of the petition be provided to Ms. Saikia today itself. He prays for and is granted 3 weeks' time to file reply.
My lord, some observation to protect the petitioner and the other students, my lord, because otherwise, my lord, there will be nothing. The petition itself will become infractuous.
Only that is not possible.
Because prima facie, it
That
is,
violation, the virus being challenged, can there be a stay?
you know, the one thing is there, my lord. Because one thing is there, my lord, that only if the 10% seat, because the
There's
council.
always a presumption in favor of the validity of the statute.
That is.
So how
there,
can there be a stay?
no, that is there, my lord. I am not
Yes.
asking for stay, my lord.
Then-
I'm only asking that 10% of the seats be kept vacant, my lord.
No, no.
Otherwise, then nothing will
Never.
survive. It will become
Absolutely.
infractuous, no, that is.
Absolutely.
Can a date be fixed, my lord?
That's why date can be fixed. Today it is, let it come on 16th August.
My lord, the counseling will perhaps finish by that date. Can it be prior to that?
There will be 2-3 rounds of counseling, Lordship.
First week of August, my lord, subject.
Try to get it faster.
Let it be on 17th of August, Lordship. Before that, we will file the affidavit.
He had given 16th. He wants
Yes.
an earlier date.
Because we want the disposal also, Lord. 17 is a Thursday, that's why.
All right, 17th August.
And Lordship has already fixed several matters on 16th. I'm deeply authorized.
Item number 38.
Yes.
May I please, your lordship?
Yes.
I have received the affidavit yesterday.
Hmm.
I will filing it today, lordship. It can be in a
Yes.
day.
Chaudhary submits that he would be filing affidavit on behalf of the Union of India during the course of the day.
Lordship, we have received a copy of the affidavit
Absolutely.
yesterday. We will file a reply within weeks.
Uh,
time, Lordship.
Counsel for the petitioner may file a reply thereto, if so desired, within next 10 days. List after 2 weeks.
God bless you, lordship.
Daily list, item 20.
May I please, your lordship?
Yes.
Lordship, make it better with Passover timing, your lordship. Senior counsel is on legs, your lordship.
Awesome. Next week. नहीं left over तो नहीं है एक ही this is the only one the only matter which is left over now. Can have it in the week commencing from 1st August list on 2nd August. Yes, correct.
Keep it.
Lodge, can it be on 3rd of, 2nd August, respect?
2nd August. 2nd August, we have given 2nd only.
2nd August.
Yes.
Item number 23 and 24.
Matters were called out for hearing.
Lordship, there is a stay order. In fact, Lordship, all the parties has submitted written argument. On the basis of that, it could have been, let it come another date next week.
None
Lordship.
present for the appellant.
All the parties has submitted written.
Yes.
Lordship, I am for the appeal, Lordship.
Yes. So
Lordship, in this case, we have already argued and we have submitted our written argument. also.
On the basis of that, Lordship can first.
this is very easy to say.
My lord, we'll have to once more request the thing. My lord,
Whenever
it's convenient. Whenever.
Next Thursday, Lordship.
the list on 20 3rd August as per it, as jointly prepared.
Much.
Item number 27.
Matter was called out for hearing. None present for the appellant. What is the matter about?
Your lordship, the appellants had participated in a selection process for forest battalion constable, and all of them were differently placed. Some of them challenged the selection process on the ground that provisions of the SC/ST rules in the act had not been followed. And some of them challenged on the ground that certain additional preference which was supposed to be given to them had not been granted. Now, during the proceedings before the learned single judge, when the records were called for, a specific statement on oath was made on behalf of the forest department. The records were not available. So in respect of those candidates who had claimed that preference had not been given for them additional qualifications, this honorable court directed us that we should accommodate them in existing vacancies. Now, regarding the infractions of the SC/ST Act, the court said, the learned single judge said that was of the opinion that that is merely an irregularity and the provisions have been followed in substance. So no relief was granted to them. They are now in appeal.
List up 4 weeks.
Item number 28.
Yes.
टाइम भी बोलना मैं स्टार्ट करूं क्या हो मैं अपनी Lordship, this might perhaps recall the matter. This particular public interest litigation has been filed with regard to the rights of the persons in incarceration and seeking compensation thereof, Your Lordships. Initially, it was filed for a single person. Thereafter, by way of judicial orders, the matter was broadened. Your Lordship will kindly peruse the last order passed by this honorable court. The State Council was required to file certain other documents and provide us with the details of the same. Now, Lordship, subject to thereafter, they have filed the compilation. They have filed that affidavit on 12th of May 2023.
Yes.
And based on that affidavit, I have made a complete compilation, which I'm just placing before your Lordships. I
Give
would
a
just
co-
take, like, to-
You will be required to give a copy to.
yes, of course, I'll be
State.
giving a copy to them as well.
Yes. What do you want to highlight?
Lordships, one of the basic things which has occurred, which has come out of the whole thing. Your Lordships are aware that section 174 and 176 of the CRPC are two different parameters or different things to be taken note of. Whereas 174 is an inquiry by the police. 176 specifically talks about inquiry in
Ministerial
certain
inquiry.
cases.
Yes.
And your Lordships are also aware that in the year 2006, 176 1A was inserted, whereby special provisions were brought in for a judicial magistrate inquiry by a judicial magistrate. Lordships, what has transpired is that in all the cases which the state government has been placing before your Lordships, not even a single
Inquiry has been made.
has been done by a judicial magistrate. They, although they claim that it has been done by a judicial magistrate under 176 1A, but the documents do not say so. Compilations.
Where is Mr. Saikia?
One to them, one for them.
Where is Advocate General?
Lordship, in this case, Council B Gupta will be appearing. He's on legs, Lordship, input number 3. He'll be arriving soon, Lordship. Order is being given in that case.
All right, come back at 2.
Lordship.
Yes. 2 o'clock. Resume at 2.
All right. This is yours, right? Not a bringing extra copies from them.
Lordship, pursuant to the order, my lord, dated 33/2023, we have filed one compilation of my lord the reports.
Yes. Not one inquiry under section 176.
Yes.
So what, what action does the state propose?
Lordship,
What action does the state propose? All the superintendents, police of the jails concerned,
Lordship,
they are responsible.
superintendent of jails, my lord.
What have you done about that?
My lord, so far as the cause of death is concerned, my lord, most of them are suicidal and my lord, rest are some, my lord.
Have you read 176?
Yes, my lord.
Read.
1A.
Read.
No.
Yeah, my lord, of course, my lord, the judicial magistrate, my lord, inquiry is not there.
Then
Yes, that part.
what is the consequence? What does the state propose in this regard?
Lordship,
You can ask the question?
Yes.
this is a my lord serious epidemic, my lord, epidemic, my lord, now. That part, my lord, if Lordship, my lord, granting me sometime, my lord, I can have the inspection. Why it was not done, my lord?
That is why the petition has been registered, gentlemen.
My lord, I understand.
That is the precise reason. So doesn't it show apathy on your part also? This status came to us in March.
Lordship.
What have you done for the last 3 months?
No, my lord, we have placed this, my lord, report. pursuant to
Yes.
the Order. Because my lord, there was a my lord amendment by the petitioner side that my lord, these 21 numbers of my lord, such my lord persons who have deceased persons, my lord, their reports are not on record.
Yes.
Accordingly, honorable court directed us to bring it on record and we have found that only 17 reports are available out of 21. That was
Yes.
pointed out. That we have brought on record. Now, my lord, after bringing it on record, it has now come to light, my lord, that yes.
So what transpires basically, your Lordships, is that this entire state machinery is completely unaware of the fact that a separate judicial magisterial inquiry is required under section 176 1A. It does not seem that anyone is even aware of that or even following any of that
That
mandate,
we
your
have
Lordship.
already observed
Yes.
in the earlier order. What
the-
explanation have you given? Have you filed any affidavit
And they have,
after 30th March?
Yes, my lord.
Which
We
is
have only
affidavit?
got on record this particular reports, my lord. By way an affidavit that we have filed.
Yes, 12th May.
Yes,
Let's see that.
12th of May, my lord. 2025.
Yes. Separate file. Okay. What have you said? Let's see.
they haven't said anything, my lord. They have only annexed the documents, that
Yes.
is all.
And the fact
And
that, my lord,
each and every one of those reports, when we have gone through the records, that is what I have placed before your lordships. And I've also just placed a chart where I have pointed out that none of these inquiries have actually, the magisterial inquiry report is not by the judicial magistrate as per in terms of the mandate of law.
Mm.
It is being done by a circle officer or an assistant executive magistrate. If your lordships will take a, for a
What-
moment,
what-
take this
what-
chart.
What remedy do you propose?
Lordships, there are several other aspects of the matter which I would also like to place before your lordships
Sure.
before I take your lordships to the consequential release which could perhaps be granted.
Yes.
Just one small this thing, your lordships, if your lordships will take up the compilation which I have just given today,
That is the
page
compilation.
46A of that 46, it starts at page 46.
Yes.
Now, this is a compilation, this is it was a interpretation of section 176A1A by the National Human Rights Commission.
Yes.
Initially, in 2010, an order was passed saying that it can be overlooked, a magisterial inquiry. This was placed as a reference before the National Human Rights Commission.
Mhm.
And if your lordships will take up page 46G for a moment of that compilation.
Yes, please.
I'm reading the
Yes.
second paragraph, your lordships.
Mm.
Inquiries shall also be held by judicial magistrate or the metropolitan magistrate. In addition to the inquiries or investigations held by the police within the local jurisdiction where the offense has been committed.
Mm.
So the inquiry is the condition precedent to determine an offense, and unless the inquiry is conducted by the judicial magistrate or the metropolitan magistrate in cases where any person dies or disappears or rape is alleged to have been committed on any woman, while such person or woman is in police or judicial custody, there seems to be no scope to determine that such incident of custodial death, disappearance, or rape, as the case may be, is an offense. Thereafter, your lordships, next paragraph.
Mm.
Alternatively, it can be viewed that the contemplation of the legislature is that in three circumstances, viz., death, disappearance, or rape alleged to have been committed on any woman within the police or judicial custody, there must be an inquiry to be conducted by the judicial magistrate or the metropolitan magistrate in whose jurisdiction the incident has taken place. The purport and meaning of the offense as inserted in 176(1)(a), presumably the death, disappearance, or rape alleged to have been committed on any woman while the person is in police or judicial custody, is that the judicial magistrate or the metropolitan magistrate, by holding an inquiry, must come to a conclusion whether the death in custody is due to torture, ill treatment, or negligence by the concerned public servant,
Mm.
culminating to an offense or a natural death. I'm skipping the next three lines, your lordships. I'm reading from the next line. Therefore, the interpretation as suggested in the proceedings dated 5/4/2010 has given a restrictive meaning where only in suspicious circumstances or in case any foul play is found, the inquiry to be conducted by the judicial magistrate or the metropolitan magistrate in whose jurisdiction so and so has occurred. And therefore, it is not in conformity with the scheme of the amendment made in section 176 CRPC. Thus, to read down the provision of section 176(1)(a) CRPC is outside the scope of the scheme of the section of so and so. Yeah, which is where here? No, no. In fact, in another PIL before the Bombay High Court, your lordships, which is at page 48 of the same compilation,
Yes.
this again, this particular aspect was called for interpretation.
Mm.
And I'm taking your lordships to page 51 of the compilation.
Yes.
The paragraph starts at page 50.
Ji.
The last line, your lordships, page 50
Mm.
of the compilation.
Yes.
Lordships have got it. Last line, subsection A of subsection 1A of section 176 applies when any person dies or disappears or rape is alleged to have been committed on any woman while such person or woman is in the police custody or any other custody authorized by the magistrate or the court. Therefore,
subsection 1A of section 176 applies in case of a death of a person or disappearance of a person or rape or any woman. This is the first condition. The second condition for applicability of subsection 1A is that such person or woman, as the case may be, is in the custody of the police or any other custody authorized by the magistrate or the court under the CRPC. And the third, I'm skipping the next few lines, Your Lordships. I'm reading from the fifth line from the bottom. Thus, the inquiry which is required to be conducted under subsection 1A of section 176 of the CRPC is an independent inquiry. This seems to have been completely overlooked by the state authorities in this instance. And this was the first negligence. The first blatant negligence on the part of the authorities in this instant matter is the complete negation of the judicial magisterial inquiry. The second, Your Lordships, negligence which I would like to point out is the manner and method in which the magisterial inquiry, alleged magisterial inquiry reports are being conducted, which I had pointed out on the last occasion, as due to which the Lordships had passed an order insofar as the main the incumbent against whom we had filed this PIL, Naresh Koch. In his magisterial inquiry, Your Lordships, what has simply been done is the earlier incumbent who had died in the Gwalpara jail, his name was Nikhil Burman. Nikhil Burman's magisterial inquiry was copied, cut, and they did not even make the necessary changes of making the changes in his name. Naresh Koch was simply substituted by Nikhil Burman. Nikhil Burman continued in the Naresh Koch report. So the negligence has been blatant throughout, Your Lordships. The first negligence has been the complete ubiquitous unawareness of the fact that 176(1)(a) is an independent inquiry which has to be conducted. Second, Your Lordships, is the fact that those inquiries which are being conducted are not in consonance with the NHRC guidelines insofar as magisterial inquiry reports are concerned. I have also annexed the NHRC guidelines in this compilation for Your Lordships' convenience. Now, Your Lordships were asking about what do I propose in so far as what could be the penal actions or what types of non-compliances. Also, another non-compliance is, Your Lordships, the non-implementation of the Model Prisons Manual of 2016. Now, Your Lordships are aware that in the in-ray matters, when they were being taken up before the Honorable Apex Court, there was a submission made by the Attorney General that the Model Prisons Manual is to be followed in toto, as well as the NHRC guidelines insofar as the inquiry reports are concerned. That was the submission, and that submission was taken note of. And in paragraph 58 in the 2017 judgment, the Honorable Apex Court has held that the magistrate has laid down several guidelines for the states to follow. Now, it suffices to say that the state should naturally follow those guidelines which are there. If I may be just allowed to read those. I will start at paragraph. What's the paragraph? I'll just read paragraph 27 for a moment before I take Your Lordships to paragraph 58. This is in re 2017 10 SCC. It starts at paragraph 26. This is the learned Attorney General who is making the submission, Lordships, at page 674. I'm reading paragraph 28. Reference was also made to chapter 13 of the manual and the section therein on accidents and suicides. Particular reference was made to paragraph 13.38, which is to the effect that when a sudden or violent death or suicide takes place in the prison, immediate notice shall be sent to the superintendent and the medical officer concerned. Paragraph 13.41 relates to custody of articles that could be used to commit suicide, so and so, so and so. It is provided that care should be taken that no such object is left about in the prison that may be used for committing suicide. Moving forward, Your Lordships, Lordships, I'm going to take Your Lordships back to paragraph 27 for a moment. It was submitted that chapter 7 of the manual and particularly para 7.95(1) thereof provides that in the event of a custodial death, the procedure laid down in the Code of Criminal Procedure 1973 and the guidelines issued by the NHRC should be followed. On this basis, it was submitted that the guidelines issued by NHRC are treated more or less as binding and are scrupulously followed. So this is the binding effect of which the Attorney General himself has made a submission. Taking note of that submission, Your Lordships will move on to paragraph 58, where the directions were issued by the Honorable Apex Court at page 686. We are of the view that on the facts and in the circumstances before us, the suggestion put forward by the learned amicus curiae and the learned counsel appearing for the National Forum deserve acceptance, and therefore we issue the following directions. First is to the Secretary General of all this court. Then 58.2, the Union of India through the Ministry of Home Affairs will ensure circulation within 1 month and in any event by 31/10/2017 of the model prison manual, the monograph prepared by NHRC entitled Suicide in Prison, Prevention Strategy and Implication of from Human Rights and Legal Points of View, and the communication sent by NHRC referred to above, the compendium of advisories issued by the Ministry of Home Affairs to the state governments, the Nelson Mandela rules and the guidelines on investigating deaths in custody issued by the International Committee of the Red Cross of the Director General of Inspector General of Police in charge of prisons in every state and union territory. All efforts should be made as suggested by NHRC and others to reduce and possibly eliminate unnatural deaths in prisons and to document each and every death in prisons, both natural and unnatural. So the guidelines, as your lordships were asking for, are already there by the apex court specified. Unfortunately, what is happening is the implementation of the same is not taken at the state level. And therefore, perhaps what needs to be done is not just a penal action, but lots of another penal action, which I was just contemplating, could be perhaps section 166, 166A of the CRPC. If I may just take your, of the IPC, if I may just take your lordships to that for a moment. Where's my book? One 166 lordships, perhaps not entirely, but that is the only thing that I could, find that if in case your lordships would want to assign liability on someone,
Maybe it can be on the aspect of the disciplinary proceedings,
lordship.
but offense.
Also,
have
lordship,
our
it
doubts.
mandates that any inquiry, if an unnatural death has occurred, what is required
That
to be
is
done is,
dereliction of duties writ large. Dereliction of duties writ large,
yes, yes.
but whether it leads to culpability for an offense, that's a questionable.
That is what I was,
Questionable.
I have my apprehensions about saying this thing, but then this is, and I would not say disobeying the law, but they're just being ignorant.
That's what
Unfortunate as it is, lordships, if I
we
may
are
also
asking
say,
you. What is the proposal from your side? What should be the remedy?
lordships, if lordships will just take up page 53 of the compilation for a moment. Paragraph 5 of that Bombay High Court. I was just taking your lordship to that.
Yes.
This could be perhaps one of the
That is
things.
a remedial measure for future.
Yes, your lordship.
So
As a
present
Lordships, in the
cases.
present public interest litigation was filed seeking compensation on behalf of those who have died. And perhaps that liability lies on the state because of the
What
fact-
has been done on that aspect?
Nothing, your lordships, nothing. Only one or 2 or 3 people. I have marked those people who have been given some amount of compensation in the chart which I have placed before your lordship. No, not just one. In this chart, your lordships, 3 cases have been accepted as an unnatural death by the state, which is 17, 18, and 19, if I'm not mistaken. And then 27 and 28, serial number 27 and 28 have been, the next of kin have been granted compensation. And there are about, if I'm not mistaken, your lordships, 20 cases where the cause of death has remained uncertain, has remained pending.
Because of HP report.
Because
not
of
received.
being sent to for histopathological report
Histopathological
sent to
report
FSL
not
analysis,
Yes.
never comes back. Never comes back. That is what has come out from this thing. I can give your lordships the numbers, and of all the 31 people who are before your lordships, only serial number 30, the last page of this chart, that is the only case which has actually
CJM
been
CJM is
inquired
inquiry.
by a CJM, Chief Judicial Magistrate cum Inquiry Officer. The rest, your lordships will find.
So would you be okay if we
Lordships.
forward this chart
Lordship.
to the State Human Rights Commission
Lordship.
for considering grant of compensation to the families?
Certainly.
I think because quantifying compensation in this rate would not be possible.
Lordships.
Is that a proper course of
Lordships, it could be also, perhaps the quantum of compensation, if your lordships are looking for, perhaps then we could take the help of the victim compensation scheme, which is
that can be,
being
yes,
followed by the state
yes,
under section 357A.
definitely.
That perhaps might be a guiding factor for the state to look into the compensation part. It is just a thought, your lordships. And certainly certain guidelines have to be issued to the authorities, your lordships, for all these
That-
blatant
that we
violations and
We can adopt the Bombay High Court judgment.
Yes,
And the NHRC's
Yes,
guidelines for that purpose. What do you say?
On that part, my lord, yes, apparently, my lord, they were conducted by the executive magistrates. my lord.
Hardly in in a few cases,
Not-
other cases, there's no inquiry at all.
apparently.
No inquiry, absolutely. Then what about the reports, scientific reports?
Not-
They are not coming.
Not coming.
And what is your proposal regarding this? Compensation?
Compensation part, my lord.
Yes.
That part, my lord, if lordship grant me time till tomorrow, my lord.
All right, yes.
Tomorrow, my lord.
lordships, some difficult, I'm traveling today, your lordship, some difficulty tomorrow, Monday, your lordship,
Monday?
subject, your lordship, Monday.
When counsel for the petitioner has drawn our attention to the affidavit filed by the state authorities in pursuance of the direction given on
33.
March.
It's been filed on 12/5/2023, your lordship.
30th March.
When? 12/5?
23. Affidavit dated 12th May. A perusal of the affidavit reveals that in only one case from the 31. One case of death in custody out of 31, which have been pointed out by the petitioner, was a judicial inquiry held by a judicial magistrate. First of, in a very few number of cases, the state has in none of these cases, एक में दिया है ना, in only one case of Arjun Saharia, the IG Prisons has granted compensation to the family members. Thus, and Government Council shall take instructions on the aspect whether the state proposes to grant compensation to the kith and kin of the deceased prisoners who, in our opinion, who as per the Petitioners Council, would fall within the category of victims as defined under section 357A of the CRPC. List on. Use the credit. Just.
One more thing I might just point out to my learned friends, perusal, your lordships. So out of 31 cases, 13 are from Goalpara, which we have been able to.
From
Goalpara district, which is absolutely an amazing figure. Naresh Coach also comes from there. Nikhil Burman also comes from there. Perhaps another thing which
the
might.
Petitioners Council has, London Council has also pointed out that 13 of the cases, incidents took place in the jail at Goalpara. London Government Council shall also take instructions on this peculiar circumstance as emerging from record.
Tuesday, your lordships.
Tuesday.
Deeply obliged. Yes.
for hearing, item 30 and 31.
May I please, your lordship.
Who's there?
Before going into the matter, your lordship, I have made a precise synopsis of the.
Who is there for the
submission
Union
by
of
Mr.
India?
Gates.
I'm for a private.
He's for the private.
Union of India.
And the rubber board is represented by
Council is-
Mr. Nath, D Nath, for the rubber board.
Pass or Karodi Nath. Call Mr. Nath. Or you can have it in the next week. Next week,
Lordship
my lord.
can have it if not possible, if no difficulty on Tuesday.
Tuesday.
Yes.
All right.
And I have a synop, I can give it today or the.
You already there on the.
No, that is a little bit, your lordship, there are some corrections. I made it, I'll
Give it
a-
on Tuesday. Give it.
I'll give it today, sir.
Okay, okay, very well.
Common correct.
Tuesday you already. So next Tuesday, there second, first August.
First,
Yes.
much of this.
Item 32 and 33.
My lord earlier entered appearance in this case, my lord Rajiv Gandhi Memorial College, yes.
Please be for the
Yes,
bench
sir.
of which Honorable Justice Eddie Chaudhary is not available.
My sir.
Item 34 and 35.
What is the appeal about?
Possible, I pray for pass of the matter for 2 weeks. Lordship.
Counsel for the plaintiff prays for short opportunity, to prepare and argue the matter. List after 3 weeks. Done.
Yeah, please, the lord.